Good morning, Leonard. It is Wednesday. It's April 16th. We are going to be in court today for the Karen Reed retrial. Well, whenever court starts, their hearing is delayed. And since their hearing is delayed and I was ready to stream, I was like, let's just go. Let's just stream. We're ready. You're ready. I'm ready. Court's not here yet. Like, when are we ever before court starts? Never. So we might as well just do it once. Like, it's just court hearings delayed. We're here. I'm sure y'all have questions. We'll answer them. We'll do a recap of what's going on. I did not stream yesterday. I'm going to be very wiggly today. My back is giving me the biz of all of it. So you'll see the wiggliness, but I refreshed my coffee. So, we're ready to go to court. Let me know what you're drinking, where you're coming in from. We're not going to have a lot of zoom room. I know, Allie, how are we going to zoom, and a boom? Look, first of all, there is no shaking of anything with my back being cranky. But second of all, I will pause. I am sure enough that we'll have a little bit of zoom room, or we'll just chat. We'll see what unfolds today, but they're not ready. So when court's live, we'll go live. Until then, we're going to roll the intro. We're going to do a summary of where we're at and how we got here. We're going to answer some questions, and we're just going to chat. We're going to chat before court starts because we're all hanging out ready for court to start. So, might as well hang out together. Hopefully today won't be a full day of a hearing, but you never know. It could be. So I'm prepared for all day. We'll just see. What are we going to do? What are we going to do today? We're going to see what happens. But until court goes live, there's not much we can do except enjoy our beverages and our snacks and wait for court to start. Though my croissant that I just made is going to be cold by the time court starts, but it's going to be fine. It's going to be fine. It's all going to be fine. Look, it works out. We're going to work it out. It all works out. Let's roll the intro and let's talk about what has happened in the Karen Reed case, how we got here, what are some of the things that are going to happen today, whenever today starts today, and yeah, then we'll go.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
I saw I Am the Real, and I lost the last part in the chat, said I Am the Real. Can we just watch Empire Records until court starts? The way I wish we could. However, I imagine we'd probably have our stream taken down for copyright. I can't wait till that happens. Like when YouTube has like a watch with where we can stream and chat. Oh, I can't wait. I cannot wait. But coffee's real good this morning. We're coffeeing. We have a new mug from the Starbucks Reserve in New York. I had a lovely day there in between meetings where I just went. It's been a minute since I've gone to a coffee shop, gotten a coffee, sat my butt down with like a book, and gotten to hang out. And by a book, just understand that I am very ADHD and dyslexic. I also have Erlen issues, so reading physical books isn't as easy for me. And so by sitting down with a book, I just need to disclose to you that what that means is I am at rapt, riveted attention with Audible in my ears and playing either Pokemon Go, Midas Merge, Love and Pies, or some other casual mobile game that won't kill my battery. And I will also have a battery backup. That is exactly what Emily sitting down with a book looks like. That's it. That's me sitting down, listening to a book. All right. So that's how that works. So with all of it, let's give a summary of where we're at, and then let's chat until court starts, shall we? We can do it. A lot of you are saying I do the exact same thing. Exactly. Audiobooks do count. B2, I saw your B2 asked, will there be a new merch drop soon? We are working on it. We're working on it. We will have a summertime little splash of some things you guys have been asking for. We are trying to navigate what it looks like to do that. As the buying and selling of things is sometimes a rocky road to navigate, but we are working on it. We'll talk about that. Michelle Peterson says tank tops, please. Tank tops are on the list. 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 So I didn't say anything. Tank tops are on the list, but we are going to have a scaled back launch to make sure that our goods do not have to like quadruple in price. So that's where we're at with that. Okay. With all of it, we need to give a road so far of where we're at, because technically we are at the beginning of trial 2 for the Karen Reed case. Karen Reed went through trial number 1. At the end of that trial, the jury was unable to reach a verdict. The court declared a mistrial, and then all the wheels continued to come off. Do we expect anything else in this case? 100% no. Is anyone shocked that in this case, where so many things are already not the way that they should ever be, that the wheels continued to come off? Not shocked at all. After the mistrial was declared, jurors came forward to the defense and to the Commonwealth and said, so we actually voted not guilty on counts 1 and 3. That's the second-degree murder and the hit and run causing death. And we didn't know that nobody was going to like ask us about if we had reached any verdicts. So we had reached those 2 verdicts and we felt like we needed to say something and we thought we'd get more information and we didn't. The jury instructions on this are incredibly confusing. Those jury instructions are not written by the judge. Those are the jury instructions for the state of Massachusetts, written by panels of judges and lawyers together. Those jury instructions say very specifically, do not come back essentially with a verdict until you've reached verdicts on all counts. Like, fill out the verdict forms when you have reached a verdict on all counts. I don't know about y'all, but all means all. So I think the jury was probably like, don't fill out the verdict forms until you reach a verdict on all counts. Okay. So when they said they were at an impasse, the notes never clarified that that was only on count 2. So they appealed through the state level appellate process, and the Supreme Judicial Court of Massachusetts said, nope, no dice, negative Ghost Rider, the pattern is full. They said that under the case law, that even inquiring of all of the jurors about whether or not they had reached verdicts necessitates inquiring into the jury's process, into their deliberations. And that is a hard stop in all case law of all kinds. It is one of the most fundamental cornerstones of our jury system, is that courts cannot invade the providence of the jury. Full stop. But case law has chipped away at that over the years a little bit. If there are issues in the jury room, we saw that in the Murdaugh case. But the issues there were outside influence from a state official, Courthouse Becky. So they could inquire of all of the jurors. The Supreme Judicial Court wasn't doing that here. So then they started the federal appeal process. And the federal courts have really ruled in line with the state Supreme Judicial Court, which is a hard pass. So now this case is pending the conference process before the Supreme Court of the United States. A quick word about that. The Supreme Court of the United States, I'm going to make sure that my phone's not going to get loud at me real quick. The Supreme Court of the United States takes up maybe 1% of cases that they get referred a year. They take them through a conference process. It is a secret process. Nobody really knows what happens, but the judges talk about cases they might want to take up. Having a case conference does not guarantee that the justices will even talk about it. It's not guaranteed. And from those conference processes, they pick the, 70, 80, 60, 70, 80 cases that they will take up a year out of thousands that are referred to them. So when it goes to the conference process later this month, it may get selected and docketed. It very well may not. And I think it's more likely not than yes. The Supreme Court picks and chooses the cases that they are going to take up for a variety of reasons. And one of the big reasons is a split of authority among the different jurisdictions. So if you have the West Coast doing one thing and the middle of the country doing something else, and then the East Coast doing something else, the Supreme Court can come in and be like, y'all stop. This is the rule. Clearly there's much confusion, and let us clarify that confusion. When it comes to juries, I don't see that type of confusion. I don't see that type of confusion in the case law, but the Supreme Court might say, you know what? Now's the time to take this case up. Who knows why they do what they do? We'll see. But generally, they only take up questions they think very much need to be resolved. And I don't think this is one of the cases that they very much think needs to be resolved. I just don't. I would like to see it resolved, but the case law is pretty settled that you got to write it down and you got to announce it in open court, and you've got to give all the jurors an opportunity to affirm, yes, this is my verdict. And none of that happened in this case because of the way that the notes were written by the foreperson. So it's pending before the Supreme Court. The Supreme Court was disinclined to acquiesce to Karen Reed's request to stay this trial pending appeal. So this trial was not stayed. This trial proceeds forward. A jury was selected yesterday, April 15th. They started April 1st. They selected 18 jurors. I think that's the right amount. We had been hearing reports that they would do, we'll do 16? And we saw that they were going to do just 16. They decided to do 18. I think that's the right amount. Because what we're going to find is even after a weekend, after a holiday weekend, you're going to lose a couple people on the jury. You're going to lose alternates. Last trial, I think they lost 2 or 3 before they even started opening statements. So do I think they'll even start this case with 18? Maybe not. Ooh, the only fan is moving. We might be going to court in just a moment. Do I think they will start this case with a full 18? They might not. Because sometimes jurors don't realize they've been selected for the jury, and then they've got a weekend and they go, oh shit, I can't do this. But they have 18. So the question is, why aren't we doing opening statements today? We're not doing opening statements today because today is Wednesday before Easter weekend. I imagine the court had intended to be off on Friday. I imagine the court had intended to be off on Monday because it is Boston Marathon Monday. It is Eastern Monday. That is a 4-day weekend. I imagine the court's already planned on that being a 4-day weekend. And from what I'm seeing and reporting, they asked the lawyers if they wanted to start opening statements Thursday or Tuesday. And they all said Tuesday. Of course they did. Of course they did. You don't want to do opening statements, one witness, and then have like a 4-day break. That's the worst ever. Also, they are a little bit ahead of schedule. The court had intended starting around the 27th, 28th, and had given that much time for jury selection. So in the court's mind, they are ahead of schedule. So gave the lawyers a little bit more time. I think that's good for everyone involved. And I think it's good for the lawyers. They're not in a rush. It makes sense. You don't want to piss off your jury immediately first. Like, do not piss off your jury right out of the gate. So the jurors get to get their things in order. Like me, I will be getting my things in order to be in trial for 6 to 8 weeks, doing laundry, making sure I have adequate snacks, getting ready for Easter with the kiddos. Like, I will also be preparing, trying to make sure like my SI joint is back where it needs to be so my hip will stop bothering me. Like, all the things. We're going to be doing things. But today they're doing hearings. Why? There are still things that are unresolved. The Commonwealth wants to use Karen Reed's interviews against her. They are statements of a party opponent. Those are going to come in. The argument will be how complete those statements need to be, because the defense cannot take an interview from Karen Reed on TV and say, we're admitting this. Can't do it. The prosecution can. Karen Reed's well aware of that. We're well aware of that. After court yesterday, they asked her and she basically said, come at me, bro. I mean, she did say, come at me. The bro was missing, but she said, come at me. They're like, they're going to use your statements against me. And she's like, come at me. going to be interesting to see if they try to do that with transcript or video. I imagine they'll try to use the videos. We're going to see a very different trial 2 than we did see trial 1. So today we will hear about what exhibits they might be using during opening statements. We will hear about what's going on with the experts. I'm sure Brennan will complain about the ARCCA experts again. We will be hearing about Karen Reed's statements, I'm sure. So we're going to deal with those last motions before trial starts. So these are not technically pretrial motions. Some of them carried over from pretrial because we are at the motion stage. So we are going to go to court. It's almost time to bring the jury. They're going to bring the jury on Tuesday for opening statements. I will be here with you. So Tuesday we'll be live for opening statements. But today we're going to do our not final trial conference, but our, motions hearing conference is what we're going to do. And they'll be doing some housekeeping. So with all of that, I saw a couple people say the Supreme Court denied Karen Reed already. They did not. They denied the stay. They have not decided to take up or not take up the case yet. So I wanted to clear up any confusion. And we're going to go to court. Are y'all ready? Are y'all ready?
Bring the jury.
I mean, the jury's not there today, just so we're clear. The jury's not there today, but it's time. It's time to go to court. It's time to go to court, Law Nerds. Hear ye, hear ye. Let's go to court. We don't have audio yet out of court, but we will. So I'm sure they're hear yeing while we don't have audio, which is really annoying. If we don't have audio here soon, I'm going to be so mad. Because I guarantee you they're doing the hear yees right now, and there is no audio on this feed. Well, that's spicy. They're introducing themselves. And yet, this feed has absolutely no audio. That is, that's fantastically bad. I wonder if it's all the feeds that have no audio. We're going to take a minute and switch feeds real quick. Let's see. Thank you, Miguelina. Miguelina was finding, I didn't even see it in our chat. Miguelina was finding a feed with audio. So there we go. I can't, multiple feeds don't have audio. Look, this is why we give ourselves a little bit of zoom room, because one never knows. What do I always say, you guys? I can hear you saying it with me. Streaming is dynamic. We did forget to fly. I do just want to fly. Well, the fact that these feeds don't have fucking audio is going to give us a minute to fly. It's gonna let us be. I'm backing up till we get me some hear yees. Oh, I hate that they have a ticker at the bottom. Well, it's gonna be fine. We can't be choosy. What would we take? Audio or a ticker at the bottom? Audio. We're gonna take audio. Let's fly, you guys. Please put your seat backs in the full upright position. I don't really know if we need to turn our cell phones into airplane mode, so we're just going to be fine. Grab the beverage or snackies of your choice, and let us go to Massachusetts. Yay! All right, to a feed that has audio. Take 2. I can't believe that feed didn't have audio. So dumb.
The Honorable Beverly Cannone.
Oh, we're going to back up. We're going to get those hear yees. I will not be denied my hear yees.
All persons have any business before the Honorable Beverly Cannone, Justice of the Norfolk Superior Court and for the County of Norfolk. Draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. Court is now open. You may be seated.
Judge 22-117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
Good morning, Your Honor. Laura McLaughlin.
And you guys are saying there is an echo. All right, let me figure that out real quick. Because there should not be. Because an echo is the worst thing ever. Oh, y'all, I am sorry. Today's going to be spicy, apparently. Let's try this one more time. All right. Again. Again. Oh, chat, I know. All right. One last time. Can't even blame Mercury retrograde.
Hear ye. All persons have any business before the Honorable Beverly Cannone, Justice of the Norfolk Superior Court and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Judge 22-117, the Commonwealth versus Karen Reed. Can I have counsel identify
All
themselves
right.
for the record?
Good morning,
we
Your
go.
Honor. Laura McLaughlin for the Commonwealth.
Good morning,
We've
Mr.
begun.
Coughlin.
Woohoo!
Good morning, Mr. Lally.
We have
Morning, Your
takeoff.
Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson.
Did they
Good
get their
morning,
bigger
Mr.
screen?
Jackson.
Morning, Your Honor. Elizabeth Little also.
I think they got their bigger screen. There had been a request for a bigger screen. That screen is screening, like it is maximum screenage.
On behalf of Ms.
Good
Reed.
morning, Ms. Little.
Morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Lessie.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti.
Morning, Your Honor. Victoria George for Karen Reed.
Good morning, Ms. George. Good morning, Ms. Reed.
Y'all,
All right, so I appreciate getting
look, we've got sound, we've got volume, we've got no echo. Woohoo!
those lists on what we all thought were still either under advisement or needed to be heard today. There's
Really?
one.
Your Honor, really? You asked all the attorneys for a list of what they thought you hadn't ruled on yet? Generally, the judge would keep a list and say, this is what I have. And then do you agree? Not give me a list of what you think I haven't ruled on yet. Emily, it's too early to be this snappy. Finish your coffee. Just finish your coffee. Just finish your coffee, girl. Just drink your coffee.
One that it seemed that. All right, we'll start. First of all, let's start with
drink your coffee.
the defendant's renewed motion that is not in writing. I think, Ms. Little, I think this was your motion
be
for a
so
forensically
mad.
sound copy. You wanted to be heard on that?
Yes, Your Honor.
You did not file anything new, right?
No, just the motion
Okay.
for reconsideration.
When was
we
that
haven't
filed?
heard
That was
that
filed
yet.
a long time ago, right?
Yes.
Okay.
It was prior to the motion.
All right.
Your Honor, the defense respectfully requests that this court reconsider the portion
waves
of
are
its
waving, Miss
February
Little.
18th, 2025 order denying defendant's motion to compel the production of a forensically sound copy of the Sallyport video surveillance footage from
Back to the Sallyport. The judge had denied this motion, and the defense is saying we have since this motion was denied, we've heard more information about the metadata. We've heard more information about how long things were saved or not saved, when they were overwritten. There is a lot more information. And she said, we cannot do our job if we do not have a copy that has all that information. And the court said, this is what they're required to turn over. They turned it over. So we are taking another crack at it where they're asking for the reconsideration. I imagine they will bring up the new information they learned since that was done.
January 29th, 2022. The court obviously understands the importance of establishing the bona fides of the Canton Sallyport video in this case. The court sat through trial. You watched the testimony regarding the inverted video. The court initially denied the request for a forensically sound copy because I believe the court indicated it did not have an affidavit from an expert suggesting that the procedure proposed by the Commonwealth and objected to by the defense would result in the destruction of metadata. We have since provided the court with an affidavit from our expert establishing that if the Commonwealth engaged in the protocol that they proposed, namely simply dragging and dropping files from the Canton Police Department computer onto a USB drive, then all of the associated metadata would either be destroyed or otherwise unverifiable. And of course, right after we filed that affidavit, the very next morning,
The very next
Commonwealth
day?
went ahead and dragged and dropped the files from the Canton Police Department computer over to a USB drive. That damage has been done. It can't be rectified, but there may still be some metadata.
I mean, if it's still on the drive, you should be able to get it though, right? Like if it's still on the drive, I can't imagine they would drag and drop it then delete it. It should still be there.
And available evidence on the Canton Police Department computer that our expert can glean if that data is properly imaged. The import of this video surveillance cannot be overstated. This is a seminal issue at trial.
The court disagreed.
I have conferred with our expert. I do believe that there's a chance that we may still be able to obtain some relevant information. And so we're asking that the court order this. I would also note that after the hearing on this specific issue, the Commonwealth produced a new report. That report was dated February 27th, 2025. And in that report, Canton Police Department Sergeant DGM Pietro claims for the very first time that he was responsible for downloading all of the Canton Police Department surveillance video.
That was some new fucking information
onto the detective drive-it issue.
Wild.
So that's everything from January 29th. That's incredibly important. We don't have all of that information, and we're asking the court to order that be properly imaged for our review.
Fair.
Okay, thank you, Mr. Brennan.
I thought they'd bring that up.
It seems the defense characterization as forensically sound is fluid. It's difficult to follow. What is clear is that we invited them to come to the Canton Police Department, bring their expert, download anything that was on the DVR, which nothing existed.
And they showed up and there was nothing on the DVR because everything had been put onto another computer. And you know what nobody from the Commonwealth said? You know what nobody from the Commonwealth said? It's on a different computer. No one disclosed that. They said, yeah, you can check the DVR. It's not there. This is not a game of hide and go seek. You're the Commonwealth. It's your job to turn things over. The narrow parsing of they checked the DVR and it wasn't there. And then your expert or your detective or whoever says, oh, well, it's on the detective computer. Stop it, Brennan. They came to check the DVR and it wasn't there. Right. It had been moved. Stop.
And then we further invited them to download the detective file. They had over a month to do that. They declined. That invitation has been ongoing. It's been constant, and it is current. If they would like to go to the Canton Police Department with their expert and download any of the detective file and see what exists, they're welcome to do that. So if they want a court order allowing them to come, which they don't need because we've invited them continuously, we'll agree to the court order. They're welcome to come anytime.
So is the Commonwealth now agreeing that we can forensically image the Canton Police Department detective file?
Yeah, it sounds like it.
Because we've been in that request.
Okay, so I really don't want you talking to each other. I want you talking to me. All right, so you asked the question.
It's some new information, Your Honor. He said, you're welcome anytime. And she goes, oh, good. Can we get the file then? Can we come image the file then? Because that's what we've been asking for. And we're literally on the precipice of trial. You want to know why everybody said, let's do openings on Tuesday? Shit like this.
To me, answer it, Mr. Brennan.
That's technically appropriate.
The defense cannot download the entire detective file because it contains files wholly unrelated to this case.
Right.
And it would then intrude upon private information and other investigations.
You're welcome, but only in the way we want you to be.
And they can download everything to do with this case. But they cannot have a photo image of the entire detective file of the Canton Police Department.
Okay, thank you. All right, so the next motion we're going to do is...
For those of you asking in the chat, why can't they talk to each other? In court, it is very much like, I don't know, marriage counseling. The judge is the mediator and the parties talk to the judge. You are not supposed to have crosstalk. Occasionally there is crosstalk, like, oh no, we can get that to you. Okay, thank you so much. But generally crosstalk is not allowed. It is more shut down by the court if it starts getting heated. If like, oh, we can sort that out later, great, is generally fine. But no, when you are on the record, there is not crosstalk. You talk back and forth to the judge. It's a triangular type conversation. When the lawyers start talking to each other, eventually you see the judge throw their hands up and say, enough, stop it, whatever. And if you give the attorneys an inch, it can get off the rails. CEG Carrie Morrissey in the New Mexico cases, if any of you watched the ASAP Rocky case out of Los Angeles, I think the word that Judge Arnold said the most in that case was stop it to the attorneys who were just bitching at each other like children so loudly, it's unprofessional. These attorneys have not done that a ton, but I appreciate Miss Little being like, oh, so now you'll give it to us? Great. Because right. But it is supposed to be like a triangular conversation. So, all right, let's resume.
Just the motion for the view. I had asked defense counsel to propose something about how Ms. Reed will get there. Have the two of you talked at all about how we're going to do our view? Two sides talked?
I don't know if that was a car or if that was a motorcycle. That engine did not sound healthy.
We haven't talked about the logistics. I'm happy to do that. I don't think that it's a very lengthy conversation between the Commonwealth.
Right, but we have to make arrangements, so that was something that I asked you to figure out. You say Ms. Reed wants to go on the view. She can go on the view. How do you propose that's done?
The simplest way would be for her to, obviously the jurors would be transported the exact same way that they were transported last time. We were on a bus. As I stand here, I can't remember if we were not on the same bus as the jurors.
Yes, we were.
We were just separated by seats, by
Right.
distance. I don't know that would be the best protocol.
No.
I think the better practice would probably be for the defense team to arrive at the same time, follow the bus in a separate vehicle, which we can provide. And Ms. Reed would be separated from the jurors the same way that the defense counsel was separated from the jurors. And
They should, if the defense is not going to ride on the bus with the jury, it should be the jury and the judge. The prosecution should be separate in like a law enforcement vehicle, and then the defense should be separate in their own vehicle. It either all of the lawyers on the bus or none of the lawyers on the bus. But the lawyers, if the defense isn't there, the prosecution shouldn't be there either. They're talking about the jury view of the scene.
And able to observe the same circumstance that we observed last time.
So I'm not going to allow all defense counsel to come in a separate vehicle because then it will be the Commonwealth in the bus with the jurors.
Put the
We need
Commonwealth in a
defense
cop
counsel.
car.
One
Stop
defense.
it. Put the Commonwealth in a cop car. Put them in a transport van. It's fine. But the judge knows exactly what the problem is. The judge is like, oh, the fuck, we're not. What we're not going to do is split that.
Defense counsel can go in a car then separately with Ms. Reed, and the rest will be on the bus.
That's fine.
I'm sorry, Your Honor, they can do what? They can do what?
Defense counsel can go in a car then separately with Ms. Reed, and the rest will be on the bus.
That's fine.
Sorry. Lest we forget we're in
I
Boston.
do need you to talk to figure out when you want to do this view. Did you want input, Mr. Brennan?
The only issue that was of difference was whether or not the motor vehicle would be at the address. The only reason I had reluctance, I thought it was unfairly prejudicial to the defense. If they decide
They want it, right? You want the vehicle.
Stop playing with me, Brennan. Your Honor, I didn't want her car. I didn't want her car at the scene. I thought it was unduly prejudicial to the defense. The defense asked for it and you said no. Bruh.
Go there at the time?
We do.
if they want it there, then
It's going to be a
I'll
long 8
agreeable.
weeks.
That was my concern at the time, but if that's that request, I'll agree to it.
Okay.
The date of the view, I didn't know if the court wanted any confidentiality in the date of the view. I would like to talk to.
So why don't I see Counsel Sidebar?
There should be confidentiality on the date of the view. There should be, because you don't need media showing up. However, the last time media showed up at the view, it was kind of funny because they all forget that they're mic'd up. They're like, you know, reality TV personalities. When they go into the bathroom, they forget they're mic'd. And they were all just like chatting away about stuff while they're at the view. It should be a confidential date. So let me finish taking a note. So that's going to happen. They are going to have Karen Reed's SUV at the location. They are at Sidebar. So we're going to zoom past Sidebar. At least we have one feed with audio. So yay for that. And we've got a little zoom
All
room.
right, so on the defendant's list, I don't understand the motion regarding Dr. Welcher, because that's been decided. So why is that here on this list? Is it erroneously on the list?
It's not erroneously, Your Honor, but Mr.
Reconsideration?
Brennan and I spoke about it. We have an agreement that will obviate the need for the court, which is my presumption. Mr. Brennan
Obviates so
is
good.
going to state it, and that would be my suggestion to Your Honor, and then we can move on to the next matter. We've reached agreement.
Okay, what's the
Perfect.
agreement?
Thanks, Alessi.
What's the agreement?
The agreement is there's going to be a
He literally just said, Mr. Brennan's going to state it on the record. And she's looking at him going, what's the agreement? What's the agreement? He's like, I literally just said Brennan was going to do it. She's like, what is it? And he's like, hold on then.
a redaction to the PowerPoint presentation of Dr. Welcher, specifically page 37. There was, according to Attorney Brennan, an erroneous remnant on 37.
Okay, so why don't you just provide me with the new slide so I know what it is, okay?
I will do that.
All right, thank you.
Thank you, Your Honor.
Okay.
Tell me what it is. Wait, stop. No, stop telling me. Give it to me.
So,
Judges need to be decisive.
Lieutenant Wing, docket 607 and 658. So what I want to know about that, Mr. Brennan, before we begin is, do you have the new report of Lieutenant Wing?
I do. I received it last night. I haven't read it, but I discussed it with counsel. I understand it's just minor edits to the original report. So that won't delay any hearing on this.
All right, so you're prepared to go forward?
I am.
All right, I'll hear you.
All right. So we were talking about Lieutenant Wing. There's a new report that was provided to the defense. Let's see.
Your Honor, the defense proposes Mr. Wing as a dog bite expert. I think it is too late to ask for a Lanigan hearing. The trial's upon us, regardless of whether or not I think I have standing for it. I do not want to delay this trial in any way. However, there are concerns about the qualifications of Mr. Wing. He has no experience in pattern recognition analysis. I can see no training.
That's right.
On his resume.
This is a rebuttal.
I will not hold the defense to the standard they've tried to employ, that he is not a medical expert, nor will I rely on Dr. Russell saying she's the only.
We are not going back to the you must be a medical expert standard, because that fucking ship has sailed. Like, the shit's out of the horse on that one. That standard apparently doesn't exist anymore, because the court has ruled in your favor, removing that standard that seems to be her standard.
On his resume. I will not hold the defense to the standard they've tried to employ, that he is not a medical expert.
That was the court standard.
Nor will I rely on Dr. Russell saying she's the only qualified individual in the country, but rather this person should have some qualification to come into court and give an opinion that a abrasion is supposedly a dog bite. It doesn't appear that Mr. Wing is a certified trainer.
When you say supposedly, I can't take you seriously. And I mispronounce shit all the time. Emily, hypocritical much? Yup. Sure fucking is. You know what? Can't help it. Can't help it. No grace left to give. It's nefarious.
It doesn't appear that Mr. Wing has ever testified in court before. And so to expedite the matter, rather than look or seek a Lanigan hearing, I think it would be helpful to have a short voir dire regarding his qualifications before he's presented as a witness, so the court can determine
You can
whether
do
or
it
not
mid-trial.
he is, in
That's what
fact,
y'all
even a
did to
qualified
the defense
witness.
last trial. Go ahead. Fair's fair. Oh my God, you guys. Fred has curled up in his hollow taco cat bed and is just as happy
Thank
as
you,
can
Your
be
Honor.
next to my desk.
With regard to the report, I just want to underscore that there are changes and I discussed these with Attorney Brennan, but I want the record to be clear. There was an objection to the original report of references to Dr. Crosby. We removed those, so those are fairly substantial.
Are there any other changes to it other than the
donut cat.
removal of Dr. Crosby?
There are, but there, as Attorney Brennan indicated, they're minor parlance, et cetera, but otherwise it's the same substance.
Okay.
Minor parlance.
So why don't you provide me with the new or redacted one as well, and I'll take a look at it.
Right,
Okay.
that has, I will do that, Your Honor. I'll provide the court with that forthwith.
That was the court feed
The
audio,
second
not
is
mine.
on the substance. Lieutenant Wing is extraordinarily experienced. You will see that in his report. The summary of his experience.
Alessi, stop. bro, stop. My ears are going to bleed. The Lawnard's dogs are going to bark. I'm turning court down because they're getting into the full sirens of it all. So I'm turning it down for a minute to save all of us.
Take a lot of time to go through it. For several years, he's been
The wee-woos are wee-wooing today.
country's leading experts on training law enforcement with regard to the use of canines, not only with bite and hold techniques, but also with what are called washout dogs, which are very much similar to civilian, some call them pet dogs. He has extraordinary experience with wound recognition. Attorney Brennan respectfully is incorrect when he says he doesn't have experience with pattern recognition. His experience is extraordinary in that regard. Your Honor will make her own judgment, but the report clearly establishes his pattern recognition. His methodology, unlike that of Dr. Crosby, is stated in his report, and in addition, he cites 2 specific studies for his report, including pattern recognition, and the whole topic of pattern recognition was well established through Dr. Russell, so Your Honor will see that as well. My last category of points to make, Your Honor, is this. The timing of this report came in light of the court's ruling on Dr. Crosby that a non-medical doctor can opine on wounds to humans.
There it is.
And we did make a motion for...
Excuse me, Your Honor. You did this to yourself. You said in the last trial, clear as day, Emily, you're never going to let this go. No. Why? Because consistency. If the judge says the rule is that you cannot testify to a medical cause of injury until you're a medical doctor, I expect that to be the motherfucking rule forever, for all sides. If it's the rule, it's not a guideline. It's not a suggestion. It's a rule. So when the court said, more like guidelines, the defense went, oh, okay, well, then we're going to need another expert to counter the expert from the Commonwealth. So now we need another expert. Your Honor, we wouldn't be here if you hadn't changed the rule, which may or may not have ever been the rule, because nobody could find it in case law or in, the legislative acts or in the rules. And he was just like, well, Your Honor, you did this.
Reconsideration with regard to Dr. Crosby and understanding the court's schedule and other matters, given that there was not an ability to have that motion determined, we then decided that we had to submit the report of Lieutenant Wing. We want to make clear that Lieutenant Wing is being offered not as a rebuttal, but as part of the defense's case in chief. And it is part of that in light of the March 6th order of the court with regard to Dr. Crosby. The aspects of behavior in combination with a wound recognition is different from Dr. Russell. There is overlap, but it's different. And the bottom line here is that the approach of Lieutenant Wing and his qualifications exceed that of Dr. Crosby. And my request, Your Honor, is...
It's not your internet, it's...
I do not believe there is at all a need for any kind of a hearing. Again, Your Honor will make that judgment when the court leaves.
It's not you, it's the feed.
Notwithstanding the qualifications of Lieutenant Wing and his methodology as set forth in his report, we would respectfully request that we have a voir dire hearing on Dr. Crosby. We have made that request of Dr. Crosby.
That's another motion. That's what we're going to hear now.
Understood. And I was just going to say, I am not going to get into.
This got rough on all of the feeds that we have monitored. Look, you guys, there is one pool feed that has to push out the signal, and then everybody grabs that one signal and pushes it. There are not multiple feeds. This is the pool feed. This pool feed is a little rough at the moment. It's probably weather related, but when I was looking at some of the other feeds, they all had issues at this particular part.
The basis for that, I just wanted to, because
that's the pool. That's the pool feed.
Yeah. So my request would be,
it'll pass though,
a determination on whether or not there's a voir dire of Lieutenant Wing abide the motion in the discussion. So in conclusion, Your Honor, we respectfully request that have a voir dire hearing on, at a minimum, wait for that determination until the court reads the report of Dr. of
It'll be
Lieutenant
okay. We
Wing.
got
Thank you, Your
closed
Honor.
captioning. We know what Alessia is saying. We're all good.
All right. So there's also a motion for reconsideration regarding Dr. Crosby. I can tell you regarding
All right. I'm going to switch feeds real quick and see how that goes. We are looking at the motion for reconsideration regarding Dr. Crosby. So if the audio is worse, I'm switching back, but we're going to give it a minute and see, because this feed's less distracting. That is all. That is all. All right. Let's hope that the audio is fixed now, since it was wild that half the feeds didn't even have audio this morning. So thanks to Court TV for having audio.
I've found that he is an expert.
That
I
sounds
am
lovely.
not going to reconsider whether or not Dr. Crosby's an expert. I'm not going to reconsider whether he can testify as something is consistent or inconsistent with dog bites. But Mr. Brennan, I don't see how you're going to have him testify as to whether these marks could have come from Chloe, the specific dog.
I don't think they can do that.
I think
Dr. Crosby is, this is from Christina in the chat. Dr. Crosby is the Commonwealth's new expert regarding dog bites. Also, we are finally getting to the croissant this morning. I was trusting Alessia. I was like, keep talking so I can eat, because I won't have to interrupt every 3 seconds. And then he stopped talking, but I wanted to eat my croissant. So we're going to continue.
That you can certainly talk about measurements that could have him test.
I'm going to back that up a little bit. So I didn't explain thoroughly. The defense asked for a motion to reconsider the admission of Dr. Crosby, the Commonwealth expert regarding the injuries to John O'Keefe's arm. So we are going to get into the court's like, I'm not going to do that. Let's continue on.
Testify as to whether these marks could have come from Chloe, the specific
Yeah, you can't
dog.
get to the specific dog.
I think that you can certainly talk about measurements that may have been made, but I don't see how he can testify.
Nobody can.
That this either was or was not this particular dog, particularly in light of the most recent National Academy of Science report that found that no evidence of an existing scientific basis for identifying an individual to the exclusion of all others via bite mark evidence. So what do you want to say about that?
Your Honor, there's a distinct difference between inclusion and exclusion. The National Academy of Forensic Sciences.
Brennan, my guy, you cannot have someone testify that marks did or did not come from a specific dog. Like, my brain's buffering. Like, how are you even asking for this? Like, how are you standing there as a full-ass lawyer asking for this? If this was like Sarah Boone or Lori Vallow asking for this, I would be like, I mean, A for effort, but no. How are you asking to have your expert testify about the identity of a dog who, again, I don't know if the Commonwealth has proven that is same dog, but the identity of a dog from teeth bite recognitions. I mean, they don't even do that with humans in criminal cases. They can look at a bite and say a human made that bite, but they're not going to say this human made that bite. Fucking hell. What?
Survey says.
Even the court's like, what are you doing? And Brendan's like, well, Your Honor. Emily, don't make fun of his voice. That's so rude. It's the vibe. It's the vibe. It's the vibe that is annoying me.
Science was an extraordinary study, well respected. I've read it many times, and that is a consensus among experts that teeth structure can in many ways be similar, so it is unfair to conclude that a particular person or a particular dog should be included or identified as the person who left that particular pattern. I agree with that wholeheartedly. It is different in kind and not within the realm of that study or any other studies that I've seen to exclude a person or a dog as the contributor of that bite. And here, there is definitive evidence to clearly show and base an opinion that the dog named Chloe was not the cause of those wounds.
Your Honor, this is his argument. Your Honor, we're not trying to identify the dog. We're trying to rule out the dog. I think you can rule out dog, not dog. I don't think you can rule out dog, but not this dog. Chad, if you just want to sing Who Let the Dogs Out in your head so that you feel better about this argument, go ahead. But he is, when I talk about the fact that lawyers split hairs, I do it too. There are arguments to be made that are very much literally splitting a single hair that doesn't even have a split end to help you get going. This is that argument. He is, Your Honor, we're not identifying Chloe. We're just saying it couldn't be. Full shaggy defense for the dog. It wasn't me. Like, dog or not dog, that's it. Dog or not dog.
That is the whole purpose of having the mold of Chloe, which is done with humans routinely, often, orthodontists, dentists, restructuring. The spacing itself.
Actually, Brennan, they don't identify human bites by dental records in that way anymore. They can identify folks who are deceased by dental records, but they're not doing it to a court degree of certainty. And a lot of dentists aren't using dental molds anymore. They're actually using digital 3D technology, which is better because a lot of those dental molds, if they're not done well, make you gag like fuck, and it's awful. But yes, orthodontists take molds. And they're not then taking that mold and like dragging it across something to see if it made a mark. They're trying to straighten that shit out with some Invisalign. Just.
Health.
Where's Dr. B when we need him? Hold on. We need Dr. B. He's teaching the future dentist of America today. He's not here.
Is so distinguishable between the molds and the spacing on Mr. O'Keefe's arm. It is an objective, a specific, and a substantive basis to draw a conclusion that there is no way to a degree of certainty that these wounds were caused by Chloe's mouth.
Your Honor, you caused this. You let them get away with wildness, and they're not stopping.
Not only that the
Give
bites
them an
were
inch.
consistent with a dog wound, but she also opined about molars in different parts of the mouth. And since the defense has decided to likely identify particular teeth and structures as the basis to say it's comparable, consistent with a dog, we should be able to counter that in rebuttal, not in our case in chief, in rebuttal, that these molds showed to a reasonable degree of certainty that these wounds could not have been caused by Chloe. So it's exclusion, not inclusion.
You can exclude dog, but not specific dog.
I'll tell you that. I'll hear from Mr. Wilson.
The court said it's an uphill battle for me, I'll tell you that. Good, Your Honor. Give it to him. Dog or not dog, that's it, sir. You can't say maybe dog, but not Chloe. And the chat said a good thing. So you agree then it was a dog. What's your expert going to say? If your expert says dog, not Chloe, still dog.
Thank you, Your Honor. I can go through this quickly. The National Academy of Science, the 2009 report Your Honor is
what the
referring
fuck?
to, there is no finding in that exclusion's okay, but inclusion is not. There's nothing in there to support that proposition. That's number one. Number two, with regard
First,
to
Your Honor, how dare
the opinion of Dr. Crosby, he did use a mold, but he didn't use the overlay. In the NAS, I'll shortcut it, 2009, the only way you even get to discuss it is you have to have the mold and the overlay. Dr. Crosby doesn't have the overlay. So even not considering the first point I made, where that's allowed for humans, you need a mold and an overlay. So there is no basis in science for the proposition that with certainty this could not be Chloe. So in sum, the inclusion-exclusion distinction that Mr. Brennan tries to make is nowhere rooted in the NAS study. And the point that Your Honor made and that we have...
Alessi, he's already been rude this morning. Can you just say, Your Honor, it's not rooted in science. It's apparently rooted in fantasy, and not even like really well-written fantasy. It's the unbelievable stuff that has no like consistency across books.
Made consistently is that there's little difference between inclusion and exclusion when you get to the methodology that's employed. So we, Your Honor, would support what Your Honor's comment was in the beginning, and that is there should be no discussion with regard to Chloe on inclusion or exclusion basis. Thank you, Your Honor.
Law Junkie in the chat said, first, Your Honor, woof. This trial, I might have to work out a Fred cam for when Brennan's talking, like a
I would
comfort
simply
cat
suggest
cam.
that there is no authority that I'm aware of that prohibits exclusion, none. And as a predicate, and I know it's a side matter, the idea of...
This is not how that works. Your Honor, they say you can't identify a dog. They don't say you can't exclude a dog. Can we logic this all together for a minute? Because I feel like I am being gaslit in real time. So let us logic together. How would you include a dog from bite marks? Well, you would have to take the dental molds. You would probably need to then make a model of the teeth, and then you would need to have a pattern from those teeth, and then you would need to compare that pattern to whatever the thing is. That's how you would say, okay, these match. The court says you're not allowed to match. So how do you exclude? Wouldn't you have to match and say, oh, but it doesn't match, and that's how we exclude it? So you still have to match. The matching is the problem. Whether the matching is used to include or exclude doesn't really matter. You still have to match it. And that step is the bad step. According to courts, like, hey, this isn't a reasonable degree of scientific certainty. So we're not allowing it in court. What? It is, and this Ricky Riley in the chat said, as a civil defense attorney, this is giving defense attorney. This is what bothers me about Brennan consistently. I identified it a few weeks back that Brennan is a special prosecutor arguing like a defense attorney. And defense attorneys have a lot more leeway in criminal court to make arguments that I would otherwise be yelling about because their job is so different. Zealous advocacy is a very different job than being a prosecutor. And he is treating being a prosecutor like being a defense attorney, and it's overreaching again and again and again. Because that's not the job as a prosecutor. And these arguments...
Chloe, as a predicate, that requires third-party culprit. And so before there can be discussion about that, there would have to be an offer of proof that we have not seen and has not been presented. So
I'm sorry, he just jumped the track into a different argument. I'm backing up.
No authority that I'm aware of that prohibits exclusion, none. And as a predicate, and I know it's a side matter, the idea of Chloe as a predicate, that requires third-party culprit. And so before there can even be discussion about that, there would have to be an offer of proof that we have not seen and has not been presented. So it really should be irrelevant. But if the
What? For all of you that are like, what did he just say? He's arguing that to even discuss Chloe, you have to get into the realm of third-party culprit. And that there has been no predicate for that. And remember, the third-party culprit is not saying this investigation wasn't great and they didn't investigate other individuals and they didn't investigate thoroughly. That's not third-party culprit. Third-party culprit is beyond something else happened than what the state says. Third-party culprit is something else happened beyond what the state says, and it is this person. That person did it. Those are two separate arguments. He is saying to even talk about Chloe specifically, you have to meet the threshold to get into this person did it. I completely disagree with the Commonwealth on this because there is room within the argument of police didn't do a good investigation to say, if you look at the autopsy and you have these unidentified marks, why are you just assuming they come from a vehicle when they do not have characteristics of what you would see in a vehicle collision? The coroner agrees. I think the argument of what happened to John O'Keefe's arm is more down the line of law enforcement did not further investigate who may have a dog and where a dog would have been on that street. And they can say 34 Fairview, dog. But did law enforcement go knock on neighbors' doors and ask if they had a dog? No. That all goes to the argument that law enforcement said Karen Reed and stopped investigating anything else. That's not the third-party culprit defense. Different. It's not well taken by me.
defense is going to try to bring it up, it's going to become a live issue. And if we have an obligation or we have a need to rebut, we want to fully rebut any of those claims.
Okay, which is why originally I was going to hear this motion to reconsider after the defense presented their witnesses. So, all right. Thank you. The substitute.
That's fair of the court. The court said, I will be more inclined to hear more about this when we get into the state's rebuttal. This may still be limited or excluded, but it's going to depend what the defense does in their case in chief. So this will come up again. That is not uncommon. It's going to depend how the evidence comes in. This is not part of the state's case in chief. It's part of their rebuttal.
Chemist.
All right, let's
is
keep
there
going.
any objection to the substitute chemist? It's Commonwealth's motion 663.
No, Your Honor.
Okay. So Jim, 63 is allowed.
Yes, Your Honor.
So you both have motions that are similar
That's
regarding,
fine.
it's the Commonwealth 669 and Defense 670, I believe. It's about the audio visual aids and giving notice. So you're both in agreement to give notice to the other
have
side
to.
before you use anything, and have you done so with regard to openings?
They have to. It's just the
Commonwealth
rules.
agrees to give notice. We've provided a number of clips of statements that we seek to use during the trial. I hope to narrow the ones that we're going to use specifically so the defense could have more notice of it. We have a clip that we'd like to offer in the opening. I'm not sure if our office has provided that to the defense. If not, we'll do that shortly after the hearing.
Okay. Who's arguing this for the defense, or who's telling me what's going
Your
on?
Honor, we're happy to provide notice. We have not yet received the particular audio clip that the Commonwealth intends to use during opening, but we're happy to provide any visual aids that we intend to use as soon as today.
All right. I'd like to see what you both intend to use in your openings, because whether you agree with it or not, I have to make sure that it's admissible, that I know it will be coming into evidence before I let you put it
Much
up there.
easier in this case because you generally know what's
Just for
coming
the
into
court,
evidence.
the Commonwealth will provide a copy to defense. That's
Okay, thank you.
Oh,
Can
it's
I
a
have
desk.
the defense, what you intend to put up?
This is a single photograph, Your Honor. I'll provide it to the court immediately after the hearing.
Okay.
Your Honor, I'll add that there are a number of statements that we have clipped. We, with the court's permission, would like to provide an entire package to the court so you can have an opportunity to view if you wanted to.
Thank you.
Did you catch what Brennan just said? So they're talking about what's going to be used in opening statements. It needs to be shown to the court. Fine. That's not unusual. The court wants to make sure that nothing comes in an opening that's going to cause an issue. And Brennan says, we have statements that we've clipped and we want to provide them all to the court to watch. They're going to, I'm sure, provide them to the defense too. They should. I shouldn't say I'm sure because I'm not. They should provide them to the defense. I'm sure if they don't, the defense will bring it to the court's attention. But they are going to clip Karen Reed's interviews for their opening statement. I imagine this opening statement from Brennan's going to be much different. Lally went through a list. Like witness 1 is going to say it's snowing. Witness 2 is going to say it's snowing and they went to a basketball game. Witness 3 is going to say that it was snowing, they went to a basketball game and there were high top tables. This is going to be a whole different situation. But Brennan's going to provide it to the court.
Thank you.
Tuesday's going to be interesting.
So I need the defense to look at this before the end of the hearing because I don't want to bring everybody back tomorrow.
Let's
if you
do it
object to
now.
what the Commonwealth intends to put in their opening. Did you tell them what it is? Like, is it something that they already have?
Your Honor. Your Honor. Your Honor. I saw a big TV in court. Let's all do it together.
They've had the materials, the interviews in total, but we've clipped the pieces that we want. It's
Put it
been an
up.
ongoing process.
Put it up, put it up.
Sent a slew of those clips to the defense.
Okay.
I want to narrow it down. We're not going to use all of them unless there's a rebuttal portion, but I want to narrow down what we're giving them. But we've been over-inclusive in what we intend to provide.
The Commonwealth provided at least 44 clips. I'd ask for whatever they intend to actually use in their opening so we can look at it for...
I think that's what they just said. They're just going to give
we'll
you.
give them the file
They said
name.
they were
but-
over-inclusive.
and If the court takes a recess, we'll give them the file
Yes,
name.
I'd like to do that just in case there's an objection. Or I can bring you all back tomorrow or Friday, and I
No.
don't really want to do that to you. So,
Thank you.
all right, so we'll just
Play
take a
them
look at
now.
that.
There's a TV
Okay,
right
so
there.
that sort of also covers, I
Do it
guess,
with us.
the defendant's, the Commonwealth's motion regarding the use of extrajudicial statements. And if you hang on while I grab that.
This is regarding what
Is
statements
there an
of Karen
objection
Reed will
to
be
that
used.
motion?
No, Your Honor.
Okay.
Can I make a note?
Yes, please.
Christy in the chat says this seems so, I think you mean prejudicial. So we're going with this seems so prejudicial. Karen Reed has an absolute right not to talk, not to testify, not to say anything. But if she says anything outside of court that is recorded in some way that it can come into court, even if she said something to a witness and the Commonwealth knew about it, they can use it against her. They are statements of a party opponent. Your right to shut the fuck up is all inclusive. She chose to do interviews. She had to have known, and her attorneys would have told her she has a bunch of attorneys and B, very smart attorneys. And they would have said, anything you say in these interviews, aired or not aired, can be used in court. She was asked about it yesterday after court, and she said, come at me. My head filled in the bro. Bring it. I said what I said. I don't think all of those interviews were flattering. I don't think all of them were helpful. There are things in those interviews that are going to be bad for her in court that did not come in last time. Lally did not go after these last time, and there were some things he could have. The Commonwealth can use all of it. However, the Commonwealth cannot just cherry pick certain statements and leave out others. Sentences must be complete. You can't Franken edit things. But the Commonwealth doesn't have to bring in the entire interview. And the defense cannot introduce Karen Reed's statements. They can argue over what a complete statement or sentence is, but they can't force the Commonwealth to put in the entire interview, and they can't put in the interview. So they have to rely on the judge to determine how much is complete. Again, a one sentence might not be complete if the two sentences surrounding it are on the same topic. But if the sentences surrounding it aren't on the same topic, it may be complete. So the Commonwealth, with these statements, has the upper hand, but only because Karen Reed gave it to them by choosing to talk. So for those of you asking in the chat, why can't the defense use the same interviews? Because it's hearsay as to the defense. And we can get into the legal nuance of all of it. It's hearsay as to the defense. The exception to the hearsay rule, because this is an out of court, this is dead ass hearsay. Emily, we're just inventing new legal words. This is hearsay. It is an out of court statement admitted for the truth of the matter asserted in the statement. For it to fall under a hearsay exception and not be hearsay, there has to be an exception. In this case, it's the statement of a party opponent. That party opponent is Karen Reed, as to the Commonwealth. This didn't get super confusing in Johnny Depp and Amber Heard because they were both party opponents. And so they were putting in each other's statements. It was like, because they were party opponents. But when Elaine tried to put in statements of Amber Heard, then it was hearsay. The other side could use them. So the defense can do one of two things. They can argue for completeness, or they can have Karen Reed testify. She's the party opponent. She can testify and clear it up. That's her choice. But what they can't do is have her choose not to testify and try to use those interviews to her advantage. That becomes self-serving hearsay and it doesn't come in. All they can do is either not have those interviews out there so they can't be used and argue for completeness. But the way those interviews are clipped, and this is the problem with giving over control, the way those interviews are clipped, there's room for the Commonwealth to argue, look, in this segment, there's only these three statements. That's fine. So Karen Reed has to choose if what the Commonwealth brings in is damaging enough. Does she have to testify to explain it? And will the Commonwealth use these statements to try to force her hand? So does it change things? We'll see. But I saw a great question in the chat and it scooted right on by quickly. So I don't, Jessica said it. Does the rule of completeness apply to opening statements? No. They can use whatever they want in opening statement. Well, not whatever, but they can use whatever will come into evidence in opening statements, but they don't have to use all of it. They can use part of it. Opening statements are not evidence, and the jury will be told that. Some of these statements might not help. I don't know if it'll be enough to overcome the other issues in this case, but the option for Karen Reed was to not do interviews or to testify. Let us continue. Because this is what they're going to get into. They're going to get into the use of these statements. That's what the court was just asking about.
Sure is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case.
Oh, that's so boring, Brennan. Bring the video. He's saying we want to have an independent reader come in and read in the transcript. Boring.
Please.
The defense, I'm sure, is aware, but I want to point out as part of that motion, we're asking to have an independent reader, someone who is not an officer or involved in this case. I don't expect there'll be any emphasis or drama in the presentation of text messages.
Boring.
An independent reader is fairer, more objective, and we'd like to have that independent reader take the stand at times throughout the case when we want to introduce certain text messages that don't involve a participant.
All right. How are you going to find this person?
Well, we could have somebody playing close from the state police, or we could find somebody that's agreeable to the defense, but I think it would be best if
You're not going to just use a law clerk? Everybody just uses law clerks for this. Law clerks are great at this. You don't have any. Oh, wait. Does the Norfolk DA's office have any law clerks? I don't know. Maybe not. Law clerks. This is what law clerks are for, or other DAs. DAs do this all the time. I did this. I loved it. People are like, I need a reader. I'm like, I volunteer as tribute immediately. Sit me down with the microphone. Let me read the tea for the jury. Yes. 100% yes. And it has to be neutral. It can't be fluffed up. You can't put emotion in it. It has to be a very flat reading of everything, which is why it's so boring.
We have an independent reader who's available throughout the trial to play that.
I know all of us are like, I want to do it. Me.
Yes.
Pick me. They need to get the AI voice that badly reads things on like social media. That's like, POV, me making breakfast, ha, 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 like that voice. Eventually, it's just going to be that. All right, I'm going to zoom as they're chatting about the independent reader.
Your Honor, thank you for the time to consult with my colleagues. I don't think we're in a position to agree or disagree at this point. I don't know exactly which text messages or which conversations.
Yeah, you can't really disagree, though.
Read.
They're allowed to do it.
At the last trial, they simply came in through the person that found the text messages. They were, Mr. Lally asked, I think.
Who trial?
I can't remember his first name. Mr. Guarino to recite the messages from both sides, and that was done pretty effectively and expeditiously. But unless I know more about exactly what the theater of having an independent reader is going to be like, I can't really.
You know it's not going to be theater, Jackson.
Go ahead.
May I?
Yes.
It is literally a flat
Wherever
reading.
there's a witness involved in the conversation, if those text messages are admissible, it would come in through the witness. Text messages between Mr. O'Keefe and the defendant, there is no author of those. And so we will introduce those text messages, the admissible ones, at different parts in the trial when they become relevant. So it's not sufficient to simply have a state police officer who is not a witness to those text messages to come in and read them continuously through the trial. Mr. Guarino is an independent witness in this case. To bring him back regularly as a police officer, I think creates the wrong impression. I think objectively we can have somebody come in who simply reads those text messages when they're appropriate to introduce.
I would
I think that's
disagree
fair.
gently with Mr. Brennan. That's exactly what the proper protocol is. If Mr. Guarino is the one who found it, he's a state trooper, he found the text messages. He was the one who downloaded the data.
Oh, Jackson, you know why he wants to do it.
Previously,
Stop it.
I think having him come back, and it doesn't matter how many times he comes back, he's paid by the state. He can come back 5 times or 1 time. But to have somebody else come in or other individuals come in to act as readers, I think that is not in keeping with the ordinary course of presentation of the evidence. It just doesn't make sense to me to have a reader come in. It seems to add a theater to the text messages that are inappropriate. I don't know who these individuals would be, and the text messages are admissible because they're
Statements of a party opponent.
Is the context of the statement of the party opponent. So I don't see any reason to change the protocol that we had last time.
Well, Brennan does see a reason to change the protocol. And on this, I don't disagree with the Commonwealth. There's nothing wrong with bringing in a reader, especially if stuff is coming in out of order. It doesn't add theater to it because they have to read them neutrally. And it's fine. But I think what Brennan was trying to get away from is bringing somebody in that's an officer and having more weight given. I also imagine that Brennan might want to bring in a female reader to read those in, depending. We will see. I also wonder if Brennan, and this is pure speculation on my part, just asterisk, pure speculation. I wonder if Brennan also wants to distance some of those text messages from the law enforcement that investigated this, so it doesn't all get mushed together. If you're already out on the witness, that it's harder to try to hear what they're saying because you're already like, I'm already done with you. So they're trying to distance some of those text messages. So we'll see.
All right. If I were to allow an independent reader, do you have a male and a female Or would it be a male reading a female's responses?
I haven't identified anybody, but I can get a male and a female.
All right.
I don't know if it matters.
That's exactly what we don't want. I think that's inappropriate. It's not going to be Mr. O'Keefe, and it's not going to be Ms. Reed. The text messages speak for themselves. The jurors should be able to analyze the words that are on the page, the text messages.
He wants
as
the
they
cops
were
to read
written
them.
and drafted, not the inflections and the repartee between two independent people with motives that may or may not be consistent with the text messages. As we all know, it's a very, very different circumstance to have a text message communication with someone and have a conversation with someone, for instance, telephonically or verbally.
I don't disagree that they should not be read conversationally like they would be in a docuseries, but I disagree with Jackson that you can't have a neutral reader come in. Disagree. You can have a reader come in. And I understand why the state wants to do it, and I understand why Jackson doesn't want the state to do it.
All the time. Things get lost in
Some of those
messages.
texts are
Having
bad.
been read by a state trooper who found them.
So it can be perhaps, not a state trooper. That's all. I
This is not a
understood it
problem.
to be to take out all infliction.
Yes.
And completely that.
Right. I heard Mr. Brennan say the same thing. I don't know that that's actually what's going to happen. And this lends itself to sort of a theatrical presentation that's completely unnecessary and could be incredibly
Sir, you're not going to win on this one.
objectionable.
You're not
And
going to
then
win on
once
this one.
It's done.
Have one of the DAs read them then.
All right. I will consider.
Y'all, stay with me. You want neutral zero inflection? Have Lally read them. Have Lally read them. That's it. Have Lally read them. That's it. That's all. So then you can bring them in when you want to bring them in. You can bring them in out of order. They will be as neutral as anything. Have Lally read them. That's it. Problem solved. Done. Neutral, flat affect. Perfect. That's it. Problem solved. Commonwealth. Make Lally read them. He's got nothing to do, and you're making him sit in court all day anyway. Destin said, didn't they do this in the, Destin to be said, didn't they do this in the Paltrow trial? Yes, this is not uncommon. This is not uncommon. Jackson is not worried about theater. Jackson has zero concerns about, well, I mean, with Brennan, you've got to have some concerns about theater. I think Jackson is worried about Brennan's defense theatrics because they mirror oftentimes his own. This isn't about how theatrical the reading of the text messages will be. This is the defense wanting to force troopers to read them in that the jury might not like, because it's much harder to pay attention to people you don't like. And bringing in a neutral reader shifts up the pacing and the text messages don't get lost, which is probably why the Commonwealth wants to do it. Distance it out from the trooper and bring them in on their own and have them be their own thing. It can tune the jury's attention back in. This is strategy. Everything they're arguing on the surface is not the main point. The strategy is underlying the argument. I think having a reader is a good idea. I think they're going to be allowed to. Chat, I see a lot of questions about this. The reader will only come in for text messages that don't involve a party typing them back and forth. So if one of John O'Keefe's friends testifies that he and John O'Keefe were texting back and forth about meeting up at CF McCarthy's, that person will read both sides of the text conversation in. If it is a witness who is testifying about their text with someone, they will testify. We are really only talking about generally the defendant's text messages because they can't call Karen Reed to the stand and be like, read these. So it's not going to be Trooper Proctor's texts. He has to read those. So these are non-witness text messages. That's it. So they're going to be texts between Karen Reed and John O'Keefe, or just Karen Reed. If there's text messages between Higgins and Karen Reed, Higgins is going to have to read them. Proctor's text messages, Proctor has to read them. So if they are witnesses, the witness reads it. This is only for text messages where witnesses are not coming in. So that's going to be Reed and if there's any from John O'Keefe in that conversation, that's it. We all good, clear. Okay. And that's, again, this would highlight Karen Reed's text messages because just somebody else is reading them in. But it's not going to come up that much. So, Incredible Anyway said, why do they have to come in at all? Because the transcripts aren't going to be evidence. The downloads may be in minimal part, but the evidence is generally the testimony. All right, let's continue.
Consider it.
There'll be no inflection. That would be inappropriate.
Thank you.
Brennan's right on that. Brennan said there would be no inflection. That's
Defendant's
inappropriate.
motion for specific discovery, paper 638.
Make Lally do it.
All right, who's arguing it?
Yes, that's me, Judge.
So we're moving on to discovery.
Before court today, Mr. Brennan and I conferred, and I think we've largely reached agreement. The only numbered items on which we do not agree are
The
3
sound
and
just
4,
got weird.
which
It's
are
not you.
related. I will say, as a preface, that we are withdrawing
not
request
you.
number 8. And with regard to request number 7, we've agreed on the following language, Judge, which I would read into the record. Number 7 would be any indication of a witness willing to change testimony in exchange for any consideration. With that, I would ask the court to allow the motion. With regard to 3 and 4, I believe that we should receive information if there's a witness who has expressed to the Commonwealth either a refusal or a reluctance to testify in this matter or to cooperate in any way.
Okay, there's no authority for that in Rule 14, correct?
We believe that it's consistent with Rule 14, which is why we've made the request.
Okay, where? Where in Rule 14 or the reporter's notes?
Relevant and discoverable. It applies to a witness's credibility, motives, intent, and that's the basis on which we make the request.
Okay, I'll hear from the Commonwealth.
Number 5?
They're talking about discovery.
Yes, with regard to number 5, we also talked about modifying the language. Mr. Brennan had taken it down for us. Any information of any witness regarding promises, inducements, or rewards to that witness.
Okay. Mr. Brennan, regarding 3 and 4, what's the Commonwealth's position?
Your Honor, that does not go to motive or credibility. It is not within Rule 14, should not be discoverable. It's irrelevant. It doesn't show any bias on behalf of the witness if they had any reluctance or concerns about testifying. I have been very broad in my agreements regarding discovery. Anything that is Rule 14, exculpatory, even their specific requests which extend beyond.
I might need to add a cat cam for this trial, but also a bird cam because we have a very sassy new blue jay in the yard who very much has favorites out of the feeder and is literally like a kid picking through trail mix to find the M&Ms and is just like, not this one, not this one, not this one, not this one. And is sitting out there just dropping the things that they very much don't want and picking and choosing the ones that they do. And the other birds are just picking up the discarded sunflower seeds because apparently this blue jay is not a fan of the sunflower seeds. It's so funny, but I am not truly distracted, but yes, I know we might need a feeder cam.
Beyond Rule 14, I am more than happy to give them, but I think 3 and 4 are personal, irrelevant, and have nothing to do with bias or credibility.
Okay, thank you. All right, the ARCCA witnesses.
Yes, let's.
Motions regarding that. So where do you stand, Mr. Brennan, with what has been provided and what you might think has not been provided?
There are
Ryan,
two issues. There is
I've been any more
the
information
discovery that
about
we
the
have
bird cam
requested in
for.
the past. At this point, I stand unsatisfied with that discovery production.
All Are you saying you will never be satisfied? Emily, stop it. I think he said unsatisfied with the production.
There are two issues. There is the discovery that we have requested in the past. At this point, I stand unsatisfied with that discovery production. And then secondly, there is the limitations that should be imposed upon ARCCA based on what has been provided pursuant to reciprocal discovery. I'd like to start with the second part.
Two
and that
issues.
is, we have a little chronology. December 5th, 2024, we submitted docket 442, Commonwealth's motion for reciprocal discovery, which was allowed by the court. There were a number of other motions which led to March 27, 2025, docket 640, Commonwealth's motion to compel reciprocal discovery of ARCCA witnesses or to exclude their testimony. And then the next day, on March 28, 2025, the defense responded with docket 642, which was a response to docket 442. And so what we were looking for, not only Rule 14, but more specifically our discovery motion, was information from ARCCA that would make clear the relationship between the ARCCA witnesses and the defense back from its inception. It is important because that information, a thorough vetting of the information, may be a basis for the Commonwealth to inquire of these ARCCA witnesses, if they're called, about candor, truthfulness, and full disclosure. And so while we've received some answers to our questions, we want a full vetting of that history. On a prior date, the court suggested that perhaps we could have a voir dire, not regarding their qualifications, but regarding this very issue about the relationship between the witnesses and the defense. That is one viable option. My concern specifically is if they are subject to a voir dire the day before their testimony, they're traveling from out of state, and they will not have with them documents and other items which are necessary for the Commonwealth's review.
You can put them on notice if she just orders it, though.
And so if the court was to maintain there would be a voir dire the day before the hearing, I would ask for an order from the
that
court
can be fixed with an order.
to order ARCCA to bring the discovery that was ordered in the Commonwealth's discovery motion back on December 5th, 2024.
This is a reasonable request.
The response by the defense.
Payment, agreements, how they were hired. It's clear with the state's witnesses. It's like, oh, you're a state trooper. You were hired by the state police. This is a fair request. Ashley Farmer said, can Brennan not depose them? The court's proposing that happens the day before they testify. His request in this is reasonable, saying if they're traveling from out of state, they might not have the information that they need. We need in order to tell them to bring it with them if we have to wait till they're out of state, because they could say, oh, yeah, I have that back at the office. I can't go get it. So it's not unreasonable, especially since the defense turned over pieces of that later. And if there's not more, there's not more. It should be fine. If the defense says there's nothing else, then that should be satisfactory. That has worked when the Commonwealth has said, yeah, there's nothing else on those video cameras. So we'll see.
Large part of it is that it's not within their custody or control. And so these items, I expect, would be in the custody and control of these ARCCA witnesses. There are a number of specific items which we sought in our discovery motions. Those items include communications, billing, emails, text messages, etc. And so those documents, if we do not obtain them in advance or the day before the witnesses are set to testify, we will never have an opportunity to send them home to get the materials that are relevant.
Yeah.
So if the defense position is not in their custody and control, then I ask the court to order the ARCCA witnesses to provide that information prior to the voir dire so that we can review it. Secondly,
Chad, I'm setting stuff up over here. I'm listening,
the
even if I'm
defense
not
has
looking
provided that
right
they
at
have
you.
retained the ARCCA witnesses independently.
I
We have
had an idea.
received no new discovery other than communications and emails. What is concerning is that in the notice from the defense, there is some suggestion about the ARCCA witnesses potentially rebutting or commenting on Mr. Welch's testimony.
Well,
Discovery deadlines have passed some time ago. It would be inappropriate at this point to have any new opinions, any new information, any new reports. We have been steadfast from the beginning of this case, early on, about discovery deadlines. And so my expectation is if the ARCCA witnesses testify, they would be required to testify pursuant to the February 12, 2024 report, and they would not be able to provide any further opinions, any further ideas, or any further reports. So the two things, to simplify it, that I'm looking for is for the court to have that voir dire, again for a limited purpose, to order ARCCA witnesses to comply with the discovery order that the court has already imposed, and to have ARCCA limited to the discovery that was properly provided before the discovery deadlines. Those are my three requests.
I'm surprised Alessi's not arguing this, but Jackson seems to have the most information about it, so maybe it's not that surprising.
I want to go in reverse order briefly, if I could. Concerning the discovery deadlines, we have continued to receive new discovery,
Your Honor, they're more
notices
like
of
guidelines.
discovery from the Commonwealth well after the same deadlines that Mr. Brennan is now bringing up concerning ARCCA. They filed their notice of completion or certificate of completion long ago, and we have consistently received new information from their experts, new reports, amended reports, redacted reports, additional information. Both sides understand that discovery is an ongoing situation, sometimes out of our control. To that point, on March 26, 2025, we received for the first time official notice from the United States Attorney's Office and the Department of Justice that we, the defense, or either side, the Commonwealth as well, were free to engage ARCCA directly as expert witnesses in this case. On that same day, we contacted the Commonwealth. Actually, the very next day, we contacted the Commonwealth and provided them information that we would be and had engaged them. We've provided the engagement agreement. We've provided them with all discovery that we have appropriate there too.
Okay.
And insofar as,
been
or to the extent that any additional testing and or analysis is completed by those experts, because keep in mind, it's only been, I mean, we can count it in days that we've actually been able to engage them. If there is in fact additional testing and or analysis that is noteworthy, then we will, or that we intend to use, we will obviously provide that to the Commonwealth forthwith, which we indicated in our moving papers. We will maintain that posture throughout. And if there is additional information to be disclosed, it will be disclosed. It will be disclosed in a timely manner. We do not have anything as yet as we stand here today, but
He said we turned over what we have.
Ballpark you talking?
When I get a report, I will turn it over the same day. If I get a report, I will turn it over the same day. If I get a new analysis, I will turn it over the same day. If we get new testing results, we will turn those over the same day.
The court created some of this problem.
In other words,
You can't expand the scope of what people can testify about late in the game with Dr. Crosby and then say, well, the discovery deadline's passed. And though the court will often make the defense fight for it, the court has let it in every time they've asked for stuff that's been late. There's been some modifications like we'll do a voir dire, but the court's let it in every single time.
Can't control the conduct of the experts. They may or may not be engaging in additional testing or analysis, but if they are, once they get it, we'll turn it over. That's all I can say to that. We're not holding anything back. We're not hiding anything. We're, as soon as we get something, if we get it, to the extent that there is additional analysis or testing done, that will be turned over forthwith.
But it's fair to say, are they doing more testing?
Docket number 642. We did, Your Honor, I don't want to waste the court's time. We did respond in detail to every single one of the 12 requests that the Commonwealth has made. I'm happy to go through those if the court wishes me to, but...
Hold on one second. Mr. Brennan, are there specifics that you say are still outstanding of the 13 or however many points there were? Because this is on what you filed. So this is not unusual. A party says, we asked for all 13. Another party says, we gave them to you. And then the party says, I don't have them. Can we narrow this? Is there anything specifically that Mr. Jackson should address?
Yes. Their response is that it's not in their custody control.
So for which ones? Which of your numbers?
Be specific.
Number one, a complete statement of all opinions to be expressed by Daniel Wolf.
Okay.
And their response is the information in the possession, custody, and control of the defense has already been produced. That obviously understates the fact that they would hope to have new opinions. That is the very point that this is not responsive. Their discovery deadline has passed. And so I would like to talk about or respond after Attorney Jackson is done about what is going to evolve from this conversation. This is exactly what I was worried about back in November. What I expected.
You brought in new experts.
Should not have happened.
The defense can respond to those.
It's difficult now to parse the different pieces of my discovery request, but we do not have all of the billing, all the communications, all the text messages, all the emails between the parties. And if the defense is not in their custody control, well, it's certainly in the custody control of ARCCA. We do not have all prior reports, all prior testing, all field testing, photographs, pictures. We don't even know.
She's like, counsel, stop.
Report.
Okay.
And so my tolerance about this ongoing development of discovery is a extraordinary problem for me. This is the number one issue I anticipated and that I've tried to prevent.
Okay. So address number one, Mr. Jackson.
The number one issue that Mr. Brennan has anticipated and tried to prevent is ARCCA testifying. Let's just call it like it is.
So address number one, please. Okay.
I am. That's what I'm doing, Your Honor. We have provided on April 12th about 1,000 pages, additional pages, responsive to the request specific to ARCCA. The response that we provided to request number one is as follows. The information in the possession, custody, and control of the defense has already been produced
and
can be found in the ARCCA report, the voir dire testimony, and the trial testimony of Dr. Wolf and Dr. Rentschler. That is specifically in response to request number one. What we have, they have. Mr. Brennan constantly stands up and says, we don't have all the emails, we don't have all the communications, etc. They have everything. We've already turned that over.
That's not what the Commonwealth's worried about, though. The Commonwealth's worried about, well, what does your expert have that they haven't given you that they're going to give to you at the 11th hour? And then you're going to be like, oh, we have it now. That's what the Commonwealth's worried about.
There is nothing that we have not turned over that's in our possession.
Right. They're worried about you not having it in your possession on
Mr. Brennan
purpose.
says this is exactly what I was worried about, etc. We could not engage these experts until we got permission from the Department of Justice.
Right.
The federal government had to give us permission. They gave both sides permission on March 26th, 2025. We immediately,
I thought you said March 6th.
Your Honor.
That's late. March 26th.
As best we could,
late.
leapt into action to contact ARCCA and engage them.
That must have been
formally
stressful.
So that they could
He said March 6th before.
Act as experts for the defense in this case in furtherance of potential testimony moving forward. We do not have additional testing results. We do not have additional analysis. We do not have.
Did he say the 26th before?
Thanks,
John. I thought he said the 6th.
Because it's only been a few days. If we get those, we will turn those over immediately.
That's way late.
And that's all we can be expected to do. If the court wishes to go through the others, it's listed as 13, but there's actually 12 requests. I'm happy to do that if the court's satisfied with.
I had a question. It was my question last time when they testified. It wasn't clear to me who did what each witness did regarding testing, preparation.
He's talking about
things that are.
He's talking about the end of March this year that the federal government said you can hire them. Like a week before this trial started. That happened very, very late.
Or normal cross-examination. Is that clarified any better? They said we. They talked about we did this, we did that.
Well, I would disagree with that. Dr. Rinschler talked about what he did, which was more on the,
in the report,
on the biological side.
There was a difference between the two.
And Dr. Wolf talked about what he did on the mechanical side. They did discuss what their individual or their specific capacity was and their expertise. We have not received any additional report to that effect. Everything that is in the report is exactly what the Commonwealth received at the same time that the defense received it, and it's exactly what they testified to both in the voir dire and in the trial. There's no clarification that we haven't asked for clarification. If there is clarification in any new analyses, that will be turned over immediately as well.
Is there anything that they're going to say they cannot provide because of the federal investigation?
That's the real
Not to my knowledge. I don't know. I haven't asked them if there's communications that Mr. Brennan is asking for that they can't provide. I haven't asked them that because I've not deigned to.
Can we consult with counsel just for a moment?
Sure.
That's a good question. I'm just taking notes.
Right. Ms. Lou I was getting to the point, but she emphasized, and I will emphasize it here, the one thing that the U.S. government has said to both the Commonwealth and to us is in furtherance of their testimony, in furtherance of their engagement, they still are not allowed to detail confidential communications that they had with the U.S. government and the Department of Justice.
But can they testify as to what they did?
Yes. Yes, that's on the table.
Can they testify under what direction they did
Probably not.
Well, they can certainly testify to what they did. Absolutely.
What
that
direction?
Is on the table.
What direction?
Every bit of testing, every bit of analysis.
But why they did it?
What their communications were, what their directives were, that is confidential. And
can I see counsel Tagbar, please?
Directive. Yeah. So the issue here is between, can ARCCA testify about what they did? Yes. Can ARCCA testify about what they were asked to do? No. Because that could give the more information that is confidential about the nature of the federal investigation that we have heard is closed. I'm going to zoom past this sidebar as best we can because this is going to be discussed a bit more thoroughly, I'm sure. We have zoomed.
So, Mr. Jackson, you're saying that the ARCCA witnesses did not do anything, did not read anything, did not consult anything, did not try any additional experiments or come to any findings other than everything that's in that report?
That is correct.
They haven't done anything
new.
That's
what we've been told. We have no reason to believe otherwise. Everything that they did, everything they were asked to do, and all the data.
This makes logical sense to me. If until March, the end of March this year, ARCCA didn't know if they could be hired by the defense team, why would they undertake anything new? A, they might not get paid for it. B, they might not be hired to do it. C, they might not be able to testify to it. I don't see ARCCA making work for themselves that they've not been asked to do. That's not what experts do. So they have no new directive. So it is what they did before.
That they were provided upon which to base their opinions and conclusions is provided in the report, and was all subject to cross-examination, both at the voir dire and at trial.
All right, and then subsequent to that, information was provided by Mr. Yannetti, and you have that all documented, whatever information the ARCCA authorities now are working on is information provided by Mr. Yannetti or his file?
So there's two issues. I want to make sure I don't conflate these. Mr. Brennan mentioned a subpoena that Mr. Yannetti had received at his office.
Mr. Yannetti had brought it up in open court.
Correct.
Yes.
That subpoena was honored, as we had to, obviously, as Mr. Yannetti had to honor it. For every single NOD that we got from the Commonwealth, that was then submitted to the federal authorities.
When was that done?
It was done periodically since the subpoena came into his desk.
When did it start?
I don't remember the date. September 1st, 2022.
Thank you.
I didn't remember the specific date, but it was very early on. So the Department of Justice, or the U.S. Attorney's Office, was receiving information pursuant to that subpoena in an ongoing basis. But I want to make clear, that's not information that was then going to ARCCA. The U.S. Attorney's Office decided what information, and the FBI decided what information to supply to ARCCA to answer their questions.
Do you know what information was provided?
Yes, it's in the report. There were 14 categories of items that were provided to ARCCA, and they said that's all that we were provided.
All right, so then it's accurate to say items that are in the notices of discovery
anything else
that ARCCA does not list were not provided to them?
Correct.
That's fair.
That's exactly right.
Okay.
Yeah, they were provided a very narrow, it was a narrow scope of work, if you will, that did not include the myriad things that we were getting in NODs.
All right, then you started providing them information to fill in those gaps, right?
No.
Once we received information from Dr. Welcher, for instance, we knew that we wanted at least to explore the idea of rebutting some of that information, from a biomechanic standpoint, and we wanted them to have basically a mirror image of what Dr. Welcher was providing.
All right, so when
that's
did you
what we provided to them.
When did you do that?
I want to say March 26th or 27th.
Okay.
I think it's in the motion.
Okay. So to break this down we're going to break it. It's time for a breakdown. We're going to break it down real quick. What they are talking about is the difference between what the federal government provided to ARCCA. Because if you remember at the first trial, there were some questions from the Commonwealth to ARCCA. Oh, so you didn't review this or you didn't review that. And they said, no, we weren't provided with it. We don't know why the federal government chose to provide ARCCA with what they chose to provide them or not. It probably has to do with the scope of work that they were hired to do. And because it was part of a grand jury, it wasn't preparing for trial. Yannetti was asked in a subpoena from the federal government to provide discovery. That's the discovery he was provided by the Commonwealth. It doesn't seem, and this is me reading into what we've learned, it doesn't seem, again, this is educated guess, not hard fact, but it doesn't seem that the feds asked the Commonwealth to turn over their file. They didn't go to the DA's office and said, hey, we're looking into this investigation that y'all did. Could you give us your whole file? They went to the defense and said, can you give us what you've been provided in discovery? Fair. So now the court is saying, all right, so ARCCA was given a subset of information from the U.S. Attorney's Office. The U.S. Attorney's Office got the information from the defense. And now the defense has provided ARCCA more information regarding Dr. Welcher after the court ruled that Dr. Welcher could testify, so that Dr. Welcher and ARCCA would have the same information and be moving forward with the same information. So we've moved on to what the defense has provided since the first trial, and that would have happened just a few weeks ago. Good? Okay, let's keep going.
Discovery for the experts for their review on March 26, 2025. That same day, the defense was provided all the additional materials to ARCCA, including Dr. Welcher's reports and all of his findings, including the 140-page PowerPoint, etc. We wanted them to have everything that Dr. Welcher had, as well as Dr. Welcher's reports and findings.
All right, and you say that you will have that, you expect, in the next 3 days or so.
Oh, I didn't say 3 days. I said I think we can count it in days, not weeks. So I would expect if there is something that we're going to receive, it's probably in the next week or 10 days, I would guess.
It's not uncommon at all that one side would say, hey, this is the other side's expert. This is what the other side was given. This was their conclusion. Can you review it? Thanks. Not unusual.
Acting as efficiently as we possibly can, but we can only do so much, given the fact that we were only provided access to hire ARCCA on March 26th.
All right, Mr. Brennan, I'll hear you.
All right. Let's see what the Commonwealth has to say. Y'all, I'm not paying attention to who's in court, not in court. Yannetti might have gone to make a phone call. Who knows?
This is the very issue I've been
coming in fucking hot. So I don't know. He might have needed to go ask. Who knows? Lawyers have a lot to do to prep for trial. Having that many lawyers in court means another lawyer can go handle other things. I'm not going to speculate as to why. He was in court this morning. Literally no big deal. It's the most of a no big deal. When I was prepping for trial, if I was second counsel, which was rare, but if I was second counsel, there were times I would step out to check in with a witness or answer questions about something or go get something. It's just they're prepping for trial.
Concerned about since the beginning of the.
All right, I will just coming in hot.
This is the very issue I've been concerned about since the beginning of this case, and I've made every effort to alert the court.
Your Honor, I'm big mad
that I had a concern. In fact, that I anticipated this very thing would happen.
And
when I
now here we
began this
are.
case, beginning of October, end of September, my first analysis was of the past history of this case and dropping experts and information during trial. My attempt was never to.
Sir, it's a bit misplaced because what you're upset that the defense is doing, the Commonwealth has also been doing. If one side had never had an issue, this frustration might be better taken by me. But this is same. He's like, this exact thing's happening. This is such a wild and unique situation with the ARCCA experts. I don't think the defense is trying to delay the Commonwealth's information in this case. The toe-tapping or tiptoeing around the federal investigation is what made all of this more complicated. The issue that I will 100% bing the defense on is not disclosing payment to ARCCA. That was an issue. The rest, and it's been disclosed now, the rest of this, sir, you guys were disclosing stuff during and after the last trial. Your rage is misplaced.
Preclude ARCCA from testifying, never. But it was to preclude the defense from trying this case by ambush. And it was my primary concern. And that is why I filed motions from the beginning of this case. Your Honor must remember, I was filing notices of intention.
Louder doesn't make you right,
anticipating,
bro.
Things that are not routine because I knew this very thing would happen. We had ARCCA witnesses where I still do not believe we have had full disclosure. Regardless of whose fault it is, I still do not believe we have full disclosure. Not just for the basis of opinion, but regarding communications between the defense and ARCCA.
You brought in Welcher.
That's why I filed this motion for discovery. And when the defense responds it's not in their possession of control, that's why these ARCCA witnesses who've made representations to this court about not knowing the defense and the limited interaction with the defense, they need to be held accountable. That information should come directly from the ARCCA witnesses if the defense can't or won't produce it. I believe there will be information that ARCCA has.
The defense has said multiple times, you have everything we have.
If you order them to bring in all of their communications, email, phone call records, billing, and text messages. And if it exists, I would like to see it. I think I'm entitled. The ARCCA witnesses provided a report that blurs the roles of the parties. I can live with that. I can accept that.
No,
the ARCCA witnesses provide a report that does not have a lot of information about their study and notes. I can accept that because I have prepared for it. But what I haven't prepared for is for the defense to wait until the last minute, then move for a tour request, which they know will take time, then provide information to ARCCA on the eve of opening statements, and then expect to come in with new opinions and information reports after we've already given an opening statement. It's not only trial by ambush. It not only takes away the Commonwealth's ability and right to prepare. It creates a disadvantage that information and argument is already made to the jury without complete information that they should have had. They could have retained any expert they wanted. They didn't have to wait for ARCCA witnesses. They've had 3 years. They could have retained any accident reconstructions they wanted.
But
they waited. They moved with a TUI letter on February 7th, 2025. Anybody with experience, including the defense, knows it takes time. If they really wanted the ARCCA witnesses, they could have moved in November. We gave Judd Welch's CV in November. We met our discovery deadlines, and they were hard. There was more we would have done or wanted to do, but we couldn't because we honored our obligations to the court and the discovery orders. We provided the discovery pursuant to the orders so that they would be held to the same standard. And now we hear they waited until February 7th, 2025 for a tour.
I'm just going to remind you, he's going to do all of this. He's going to do all of it. He's going to do all of this. Don't let him spin you up. He's going to do all of this. He's going to make his record. He's going to whatever. The court's going to allow it at the end of the day. At the end of the day, the court's going to allow it. And if ARCCA has new opinions that they're allowed to bring in because the court expanded the ruling, they're going to allow it. So just yell into the void, sir, because it's not going to work. Sure, you're probably frustrated. Okay.
Request. And now they're giving new information to ARCCA to come back.
Well, because you have a new expert.
And potentially give new opinions that
a
we
new
have
expert
no
nobody
ability
thought was going to be allowed in.
to evaluate. We have no ability for our experts to then go through and conduct more testing. This is the core of preparing for the case. They had that obligation. And so now to allow them to do this, it's not an aberration.
What's going to happen?
This is a continued pattern from the last trial. They have their ARCCA witnesses. They have their report. That is all pursuant to discovery deadlines. To now let them change the rules and come in tomorrow, the next day, or 10 days from now and have new opinions after we've already told the jury our theory and our science and not have a chance to rebut it or consider it, I'll have no time during trial.
Your theory shouldn't change based on ARCCA. Sir, that ship has fucking sailed. Your theory of the case, you're telling on yourself, Brennan. Your theory of the case, if you had a strong case, your theory of the case should be unshakable. No matter what the defense expert says. If the defense expert can come in and change your theory of the case, you've already lost. Nothing at this point, how many years in are we now? 3+, should change your theory of the case. Your theory of the case is built on your evidence, your experts, your expert opinions. If you have to modify your theory of the case based on what ARCCA may say, you're done. You know that. But you're talking like a defense attorney up here. A defense attorney might change how they argue that the state didn't prove their case based on an expert opinion. Not the Commonwealth. If the evidence is truly a mountain of evidence, it's unmovable, no matter what the defense does. So you are just you can see the frustration of them trying to find a theory of the case. And that's not where we should be before a retrial. Your Honor, we're already going to tell the jury our theory of the case. What happens when ARCCA comes in and says shit that completely undermines our theory of the case? Your coroner undermines your theory of the case. What is your theory of the case? It is so clear when you see other prosecutions and you see opening statements where the prosecution gets up and says, in this case, the evidence will show A, B, C, D, E. And at the end of the case, we're going to ask you to find the defendant guilty of XYZ. And when it is just a word salad, you can tell that there are too many straws being grasped at. Whatever you think happened that night, and I know some of you think that the defense has reached too far on a conspiracy with like 1 million participants. I get it. I know some of you think that Karen Reed 100% hit John O'Keefe with her car. Okay, here's where we're at though. In our system, the Commonwealth has to prove it. And their case has not been good at proving it. They have to prove what happened that night. They have to prove that the investigation shows that beyond a reasonable doubt with lawfully obtained evidence and credible witness testimony. That is their job. And then the defense comes in and goes poke, 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 poke. And if the defense pokes enough holes that the whole thing falls apart, your case wasn't very good. Because most of the time, by the time you take something to trial, the defense can poke all the holes they want. It's not going to sink your battleship. I have mixed analogies ridiculously. And that is the difficulty with this case. Whatever you might think happened that night, the ultimate question here is, can the Commonwealth prove it? And if they are this worried about a defense expert, it is because they know that they are one hole poke away from the entire thing collapsing. If that is your case, don't take it to trial. There are plenty of cases that come across the desks of prosecutors and they look at the case and they're like, yep, sure seems like that person did the thing that we think they did. However, I can't prove that. Do I think they did it? Yep. Can I prove they did it? Nope. The next solution is you don't file the case. Period. That's it. This is just so frustrating to see. It should not feel like the prosecution is reaching and reaching and reaching. And it is not the role of the prosecution to reach like this. It is an overreach. All right, I'm going to back up because he seems to think that ARCCA is going to sink his battleship, and now he's saying the quiet part out loud. Let's continue.
Come in tomorrow, the next day, or 10.
Because he's so mad.
They have their ARCCA witnesses. They have their report. That is all pursuant to the discovery deadlines. To now let them change the rules and come in tomorrow, the next day, or 10 days from now and have new opinions after we've already told the jury our theory and our science and not have a chance to rebut it or consider it. I'll have no time during trial to sit down with the experts and assign them to review new information, new reports. I'll have no time to go
They're
back
responding
and
to your experts.
Consider the order of witnesses or the information we need or witnesses that we've decided we don't need in this case and scheduling. If it wasn't so obvious this was going to happen, I wouldn't be so upset about it. At some point, the defense has to be held to the same standard of discovery obligation. This isn't late notice. This isn't parachuting in. This is an effort they decided to make and wait until February 7, 2025. Your Honor, I ask you to allow ARCCA to testify, allow them to testify to their report, be confined to the report that has met discovery deadlines, and to produce the request that the court ordered regarding discovery of the information that we want. That's what I ask this court to do.
You made your record. Fine. That's not going to happen. The court's not going to limit the defense in that way.
Your Honor.
And some of what the defense is doing is responsive to new experts from the Commonwealth. There have been discovery failures on both sides of this case. For Brennan to be holier than everyone with the defense discovery is wild, because the Commonwealth's discovery obligations have been pretty shit as well. ARCCA should be able to respond to the Commonwealth experts. Yes, that. I said it in the right order.
Feigned indignation is just not.
She's going to get mad at Jackson
with the
for that.
facts. We didn't receive Judd Welcher's report until basically February 2025. We received a report, I think it was January 31st.
Are we going to just rehash all the discovery failures?
And we read it for the first time the next day on February 1st. Nobody's been dragging their feet. There is no ambush. This feigned indignation is just not consistent with the facts, Your Honor. The court hadn't ruled that we could even use ARCCA until just a few weeks ago. We've been moving expeditiously to try to rebut a witness that the
It's completely
Commonwealth
new.
disclosed in February of 2025.
And the Commonwealth is going to say, well, we needed that expert because of your expert. It's going to be the Spider-Man meme where they're all just pointing at each other. It's like, well, we needed a new expert because of your expert. And then we need a new expert to rebut your expert, but we only have an expert because of your expert.
In March, we asked for a two-week request. We asked for a two-week permission, or asked permission to engage them through a two-week request. That does take time.
And it took a month.
We weren't waiting for some advantage. As soon as we got the request approved, we immediately, that day,
because they didn't have time
and immediately
to engage
that
a new
same day,
expert,
provided
probably,
the
or
Commonwealth
resources.
notice that we had engaged them, and we intend to use them to, at the very least,
this isn't going to change
to address
how the court rules.
Judd Welcher's testimony or his reports, the last iteration of which we got on March 24th. So if you want to talk about dates and chronology, what's good for the goose should be equally good for the gander. Mr. Brennan has been consistently providing us with new discovery after his certificate of compliance has been well done, the ink is well dry.
Right.
We have a right, we have an obligation to address and to meet his new discovery. For instance, Judd Welcher's opinions and conclusions, with rebuttal opinions and conclusions.
And the court opened the door by allowing it.
And I want to make sure that we're not conflating two separate issues. One is the information that ARCCA had outside of any of our control. Nobody in this courtroom could have reasonably controlled what information they had.
But you did say that's all listed in the report and there's nothing more.
I was just about to say, the communications that they had with U.S. Attorney's Office, I don't have any access to that. That's confidential. But I do know what they provided to them for their analysis. That is all listed in the report. And both sides have had that from the day we received the reports, the federal disclosures. Both sides have had those. So nobody was in any disadvantage in the first trial, and certainly nobody is at a disadvantage in this trial. We're simply trying to meet our obligations as we could within the confines of the rules that were set up in no small part by the federal government. And now those strictures have largely...
For those of you asking what's with all the court officers, I would guess they heard Brennan and Jackson getting spicy and other courts were boring and they came in to watch because it makes your workday more interesting. That would be 100% my guess. Everybody heard the voices get raised and we're like, oh, shit's popping off in court. Let's go see. So don't tell me you're not nosy at work. If you were at work today and you heard this happening in court, wouldn't you just be like, we're going to just mosey on down there and see what's going on? You 100% would go down to that courtroom and see what's going on when you heard how loud they were getting. You would want all of the tea. 100%. If the other courts are done for the day, that's what's with all the court officers. They want to see these attorneys yelling at each other.
Been lifted.
and we're moving forward as expeditiously as we possibly
You know you would. All of us want all the tea at work. Tracy and B2, thank you guys for the gifted memberships. You have soothed the nerves of the chat by gifting them memberships. The chat is now not on slow mode to bang their fingers against the keyboard and say, but you're not turning over Discovery either. So thank you so much for the generous gifted memberships, Tracy and B2 and everyone else who's gifted memberships. Thank you guys. Welcome, new members. Welcome to No Slow Mode.
Their obligations. It's always an attempt to assign blame. The government or the Commonwealth gave us late disclosures. The changes in Judge Welcher's PowerPoint were by exclusion. Attorney Alesi had concerns about certain things in the report. So we took things out of the report.
Fred, what are you doing?
There's a difference.
So you first provided it in November, then you're saying?
No, we provided, pardon me. We provided the
the
CV
date's
in
right.
November. And then we provided on our discovery deadlines, January 31st, 2025. And then on February 5th, we provided all of the detailed background notes, references. And so we met our discovery deadlines. The changes to Mr. Welch's report have been the complaints, understandably, about what they believed was hearsay or inadmissible. So we removed pieces. There was no new testing. There was no new reports with information changing any of the things.
But it sounds like ARCCA's not doing new testing either. I don't even think they have fucking time or money for new testing. It doesn't sound like ARCCA's doing new testing. It sounds like ARCCA's reviewing what your expert reviewed, which is fine.
According to Mr. Alesi,
I'm not mad at that at all. Are there times that Jackson gets a little too spicy, a little out over his skis? Yeah, there are. But on this one, no, 100%. 100%. Emily, have you been corrected a million times on how to pronounce a name and still get it wrong? Yeah, once it's lodged in the brain, sometimes it still gets fucked up. But this is hilarious.
according to Mr. Alesi, who is much more facile with the facts of what's in Judge Welch's report, that's not quite true. There were additions made to the latest iteration of his report. And Mr. Brennan just admitted that February 5th
spoke in all caps.
Was the first time that we received all of the information from Judge Welcher. The next month, within a few weeks of that, that's when we received permission to hire ARCCA. That's when we received permission to engage ARCCA. That's when we provided the individuals at ARCCA with everything that we had been provided just the month earlier. So there's no ambush. There's no attempt at taking an advantage vis-a-vis time. It just doesn't, the arguments just don't play, not with the facts and the chronology of what we've been doing and we're continuing to do.
All right, thank you. I think is the only thing left.
The court's like, moving on.
The motion to sequester Aidan Kearney to remove him from the sequestration order. Is that the only thing that's now left outstanding?
No, Your Honor. There's also a motion in limine that was outstanding. It's the Commonwealth's motion in limine to prohibit reference to any pending internal affairs investigations.
Yes. Where do we stand with that?
Okay.
I thought that you were going to.
We had a chance to review the file. If there's any statements that are relevant, we think the defense is entitled to use those statements for impeachment or cross-examination. As far as the rulings,
that's accurate.
Administrative bodies' rulings, that should not be permissible. It's an opinion of a third party, and then it will open the door to the explanation that those sustained findings are limited to certain conduct, but don't include other types of conduct which we would need to rebut. A third party's opinions are not admissible to impeach a witness.
The defense vehemently disagrees with that assertion. That's not the state of the law. We did provide notice to the Commonwealth of what we intended to admit at trial. The Commonwealth was conversely ordered to provide notice to the defense of what they were specifically asking to keep out. That was supposed to be done 2 weeks ago. I emailed Mr. Brennan the next day after it was due. They did not respond. I was told this morning they're seeking to exclude everything.
What?
I would like to be heard on that.
Yeah.
Your Honor.
All right. So I don't have a copy of what.
This issue was much more clear legally. Well, I think it's clear now too. This issue before, and now we are talking about internal affairs investigations. If there is an ongoing investigation, that does not come up. When the investigation is concluded, that can come up. Brennan said, we agree that some of these specific statements can come up, but not the ultimate rulings or findings. Like the firing can come up, but what they found can't. So now they're going to argue about this because now that the IA investigation is closed, the question is how much of what was found comes in. All right, let's continue on.
What it is you intend to introduce, right?
No, we provided notice to the Commonwealth, but
So I need that. Do you have it?
I can articulate it to the court. We want to admit the sustained findings that have been made against 4 separate officers in this case.
You know what? I do need that in writing. I need this in writing. I need a Commonwealth's response.
We needed to have a ruling on this in advance of.
Excuse me?
We need to have a ruling on this in advance of Monday.
Right.
I can try to get that to you today.
All right. Get it to me today. I'll decide it tomorrow.
Okay. Are we allowed to make an oral argument as to this issue? It has been briefed already by the Commonwealth.
Okay. You know what I need is
The court wants it written because the court wants to know exactly, and I don't blame the court for this at all. The court wants to know exactly what statements you're looking to admit. Like, not just we want the ruling in, it's we want the ruling, and the ruling is verbatim, so there's no wiggle room later. I don't blame the court for this in a case this voluminous, because these decisions can be incredibly nuanced. And so exactly what language the defense is asking to come in will matter in this. So I understand the court saying, I'm going to need that in writing because the court will need to rule on those things specifically. This is not the court just being extraneous. This is a legitimate concern because the ruling needs to be specific. And the law goes, there's nuance to this area of what can and can't come in. And there's a lot of nuance. It is not a clear, clean cut, this is all in, this is all out. So I think, or I would like to see the court allow oral argument and then ask for specifics on what they want to come in. But the court has so much patience for Attorney Little because Attorney Little is completely fact-based. There are times she will get a touch spicy, but it's not nearly as hyperbolic as like Yannetti or Jackson gets. And she and the court work very well together in that way. And when the court asks for information, she doesn't spin sideways and go, I'm getting there, like Yannetti will do. She will answer the court's question and then move on. They work well together.
Expecting this here today. So what I need is the paper number. I think it's the Commonwealth's motion to exclude. But the last I had it as it wasn't under advisement. You were going to figure out what the objection was.
Yeah, the court
and
likes
what
Miss
you
Little a lot.
wanted to put in. All right, so we need to take a recess anyway so that you can look at the video to see whether there's an objection to the opening. So why don't we take a 15-minute recess?
No, we want to watch the video
and
together.
Ms. Little, if you can provide just the paper number and what the Commonwealth's response was.
It's paper number 588.
All right.
Can we watch the video
Jim,
together?
I need that.
Your Honor, motion from the lawn. Motion from the Lawnards. Can we please? Can we please? Also, for those of you saying the court respects Miss Little follows the court's rules well. And this court has said, just like Judge Hippler has said, I do not want the hyperbole. Miss me with the accusations, allegations. They did this, they did this. The court is like, what I'm not here to do is navigate a bickering match between the attorneys. And Little meets that expectation every single time and answers the court's direct questions directly. So Little reads the room very well with this judge. And I think Alessi does too most of the time, but there's times when Alessi is so pissed that he can't help himself. It's rare. But when when Alessi gets pissed, he will get a little hyperbolic too. So let's continue in court. We zoomed past the court break. The defense over the break, the court said, was going to have time to review what statements from Karen Reed's interviews might be used in opening, and then they're going to review what internal affairs rulings may be able to come in and out. We'll see. So let us go back to court.
We were able to see the video, and we have no objection. And
I would back this up just a
objection to what you saw.
I zoomed way too far. All right. Hear ye, hear ye. Court is back.
Court is back in session. You may be seated.
Yes, Alessi's dander gets
All right,
gets
so
up
the first thing I viewed the clip. Is this only 15 seconds? Did I see everything you intend to use?
I expect that's only 15 seconds.
Okay. Was there any objection to what you saw?
no objection.
Okay, thank you.
I would say that's only the audio. There's a visual that goes with it, but because it comes from a broadcast, we have to copy it differently.
Okay.
That's the audio, but there will be the visual with it that was aired.
Okay. I was able to see the video.
Super.
Okay. All right. Were you as well, Ms. Little?
Yes, we were able to see the video, and we have no objection. And I did also provide, there's only a single photograph we intend to display. It will be an admitted exhibit. I provided a copy to counsel. I will also send that to the court as well.
Okay, thank you. All right, I'll hear you on this motion. Ms. Little, I'll hear your response to the Commonwealth's motion.
So during the break, we had an opportunity to discuss this issue with the Commonwealth.
Okay.
I believe we are in agreement on most of the issues.
Okay.
They have agreed that we are allowed to bring in the sustained findings as they relate to Trooper Proctor, Trooper Buchnick, Detective Lieutenant Tully.
Okay.
The only issue that we need to work out, Your Honor, is with regard to Kevin Albert. And so we will continue to discuss
That's
that.
a little
I'm
harder.
not as concerned in terms of timing with that particular issue.
Okay.
If the court will give us, another day or two.
Yeah, if he's
to
not a
discuss
witness,
with the
that's
Commonwealth. If there's a remaining
different.
issue, we can address that promptly with the court.
Okay. Can we address, is it something you need for your opening?
Not with Albert.
Okay. All right. So yes, we'll address it sometime next Tuesday or Wednesday. Take your
Jackson,
time in
if Little's on the
working
record,
it out.
don't stand
All
up
right.
and talk over her.
Okay. So now
I know
is
you're
the
doing opening,
only
but
thing
still.
left the motion that Mr. Bradle's here for?
Okay, they took 15 minutes, and the Commonwealth and the defense had a little chit chat, and the defense probably said, "We are going through the sustained findings, not the reasoning, the sustained findings," and they probably said, "And you can't stop us." The Commonwealth should know that they cannot.
As far as I know.
Okay. All right.
Okay, well, that was resolved.
Morning, Mr. Bradle.
Good morning, Your Honor.
Okay. So,
Moving on.
Jim, you have that.
This is going to be, Mr. Bradle has come into court because he represents Aidan Kearney, aka Turtle Boy. He's here because they are talking about whether or not Turtle Boy, who is on the witness list and also a member of the media, will be allowed to be in court or will be sequestered out of court. There's already been a motion regarding Gretchen Voss, same kind of motion, that was unopposed to allow Voss to be in the courtroom, even though Voss is on the witness list. So same type of motion. Can he be in the courtroom as a member of the media while being on the witness list, or will he be excluded from the courtroom until he testifies, like when and if he testifies? So that's what this hearing is on. Let's continue.
All right. I probably have it here too.
So that's why a different attorney is
I have one,
in
Jim, thanks.
the courtroom.
All right.
For that, Dottie said if Voss is there, then he should be able to be there as well. They are very differently situated. So I would not, that is not an apples to apples comparison. So it is different. Yeah, they are very differently situated. So let's see what Mr. Bradle has to say.
I will hear you. Let me just ask, Commonwealth, you're moving to, sorry, you stay right there, Mr. Bradel. Mr. Brennan, you're asking for sequestration on all the witnesses other than the ones that have already been decided, right?
I'm not sure I understand.
So there was already an order on who is exempt from the sequestration order, family members. We discussed, and there was an order on all of this.
Yes.
Are you asking that Aidan Kearney be sequestered?
I am. He's a named witness.
Okay. Does the Commonwealth intend to call him in your case in chief?
It depends on the development of the case. There are two issues that are important.
It depends.
One case in chief is whether or not there's any development of third-party culprit. If there is, Mr. Kearney becomes a more important witness, and we'll have to assess that as the case progresses. The other is rebuttal. If the defense calls the defendant to the stand, then it is a strong likelihood that we would call Mr. Kearney.
Okay.
Those are two things that I can't anticipate at this time.
Okay. All right. Now I'll hear you, Mr. Bradel.
All right. Thank you very much, Your Honor. Judge, we don't have an offer of proof. I'll try to argue in the interest of time, and I think I know where the court's going with this, based on the prosecutor's statements and the context. So with that understanding, Judge, I would just start by saying that, there's really no reason to beat around the bush here, Your Honor. The Commonwealth is not going to call my client, Mr. Kearney, who for the record is in the second row here today.
Can I just ask, if he were to call your client, would he take the fifth?
Yes, Judge, and I just should clarify for that.
Okay.
That is under the government's, the obviously well-established position of Norfolk County law enforcement. What we contend is a twisted interpretation of the witness intimidation statute, that seeking to contact witnesses, seeking to question people is witness intimidation.
Okay, so just focus back on...
So the answer is yes. I'm sorry. The answer is yes, Judge.
Okay. So let me hear from you on that, Mr. Brennan.
Sure. Your Honor, under the government's interpretation of this statute, Your Honor, the government is seeking to first...
No, I'm sorry. What I said was I'll hear you, Mr. Brennan. And you
I'm sorry.
But that's okay.
Brennan, Bradel, B.
I don't want to hear about the witness intimidation statute, other than if I don't sequester your client, I would be inclined to do just like I did before.
Yep.
The witnesses who are the subject of the indictments, Mr. Kearney will have to be outside the courtroom when they testify.
We anticipated that, Your Honor, and I won't say that we would agree to that, but I understand the court's position there, and I can see that would be a resolution the court might land on.
Okay. Now I'm going to let
It's a
Mr.
clearer
Brennan speak,
issue.
and then I'll hear you again, Mr. Bradel.
Thank you.
Your Honor, you have questions?
Yes. What if he takes the fifth?
If he asserts his Fifth Amendment privilege, I think there is no realistic likelihood that we would call him. There's obviously procedures the Commonwealth could follow, but I have no belief that will happen. So I expect if he actually asserts his Fifth Amendment privilege, would no longer have a good faith basis to say that there would be a need for sequestration. I would ask the court to impose the prior limitations with named victims and also minor witnesses.
Okay.
But I would, as a predicate, he would need to assert his fifth.
Do you need that to be done formally?
On the record.
You want it to be done formally?
It would have to be done formally.
Mr. Bradel, do you want to do that now?
Judge, I'm happy to assert that on his behalf.
Would reject that invitation. If he wants to assert the Fifth Amendment privilege, he can assert it.
He's going to have to do it, yeah.
Okay. Do you want to call him now and do that now, Mr. Bradel?
He seems to want to.
Not? Do you want to talk with your client?
Client looks happy as fuck.
Sure.
Client looks...
Why don't,
client
you know
looks,
what? I'll give you more than a minute, Mr. Bradel. Can the staff work through lunch for a little bit?
Yes.
Client looks like he's ready to go.
All right. Mr. Bradel, why don't I give you 10 minutes to talk to him? We'll see you back here in 10 minutes.
All rise for the court, please.
Yep. What Brennan said at the end of that was, if he is going to plead the fifth, and in Massachusetts, you don't do it in front of the jury. If he is going to plead the fifth, then he needs to do it on the record. And if he is going to assert his Fifth Amendment right because he has pending witness intimidation cases, then Brennan said, then I have no good faith basis to sequester him because he cannot be called if he's going to plead the fifth. And the defense counsel said, well, I can assert that he's going to. Brennan says, I'm disinclined to acquiesce to that assertion. If he wants to do it, get on the stand, get under oath and do it. So the pending witness intimidation cases seem to be the reason that they will be unable to keep Turtle Boy on the witness list because he's going to say, I'm not saying shit to you and I don't have to. All right, let's zoom past the court break and get back into court. If y'all are asking me about I am not going to be evaluating those cases. I'm not going to evaluate them today. We're going to see what plays out in court as it plays out with relation to this case. So for those of you asking, what about this? What about that? I'm not evaluating it. I am not making a judgment call. I am not evaluating that case. The government has charged those cases. There are witness intimidation cases pending. That is the fact of where we're at. What will happen with those cases? We will see. But it is a reason to keep him out of the courtroom if the witnesses who are part of those indictments testify, then keeping him out of the courtroom makes sense as to those witnesses, but not to everything. So we will see.
Court is back in session. You may be seated.
Let's see what happens.
Mr. Brennan, do you agree that Mr. Kearney has a Fifth Amendment?
He does.
I think he has a Fifth Amendment privilege. I don't know that he has a Fifth Amendment privilege to all questions we would ask, but the content that we would go into, I think he clearly would have a Fifth Amendment privilege.
All right, so you're not asking for a lumen.
The only reason to call him would be to talk about his contact with Karen Reed or his contact with any of the witnesses. All of that would go to his case. What else would you ask him about? That's what's relevant.
We would go into, I think he clearly would have he has a Fifth Amendment privilege. I don't know that he has a Fifth Amendment privilege to all questions we would ask, but the content that we would go into, I think he clearly would have a Fifth Amendment privilege.
All right, so you're not asking for a Lumen Martin hearing?
I'm not. I think I necessarily would have to delve into issues regarding his open indictments against a number of different victims.
Right.
Okay.
And I think there's other information that I can't discuss for other reasons because of court orders.
Okay.
Right.
All right, thank you.
Judge, I would suggest that the court could take judicial notice of the 16 indictments against him.
So the Commonwealth concedes, and I believe there's a valid Fifth Amendment right. So
I ask that you just allow me to make the reference.
The Commonwealth concedes because dragged. They were dragged through it to concede. They can't not. What relevant information does he have as to this case other than the witnesses and connection and conversation with Karen Reed, which all go to the 16 indictments? Right. His name? Okay.
Presentation on behalf of Mr. Kearney that he would, in fact, invoke his Fifth Amendment privilege. Commonwealth agrees to it. I ask that you just allow me to make the representation and leave it there.
Nope, that's not going to happen. I don't think.
Is there any objection for everybody hearing this?
There is. I would like.
Yep, they're not going to let that happen.
Oh, I thought you wanted a basis. No, I'm going to see Mr. Kearney here at sidebar with just you, Mr. Bradle.
Thank
And
you.
all recording devices are off.
Thank you.
They're gonna do-
FTR goes to sealed, Tory.
They're going to do a colloquy with him to have him plead the Fifth on the record, but it's going to be sealed. Okay. For those of you, I saw a couple of you say victims. Yes, that is how the witnesses he's accused of intimidating would be referred to, because there are individuals on all of those 16 indictments. Those individuals would be referred to as witnesses. This is going to be sealed. This will also probably be under gag order, I would imagine. So we're going to zoom as best we can, because the court is going to get all of that on the record so it doesn't change. I imagine it won't. I can't see why it would. So if that is sealed, it might also be under gag order.
All right, so Mr. Brennan, I've just had a colloquy with Mr. Kearney, with his lawyer present, obviously. I find, and the Commonwealth concedes, that he does have a valid Fifth Amendment right. I find that there's a valid basis for him to invoke that Fifth Amendment privilege, and I find that if he were called to testify, he would in fact invoke that Fifth Amendment privilege. So based on that, he will be exempt from the sequestration order, except as to, and I need a list of the named witnesses who are the alleged victims in the current indictments.
I accept those findings. We'll provide the court with a list of the named victims.
You don't have
we
any
also would like to
to
have
do
the court
but
consider
accept
the
them.
2 minors in that list.
Oh, yes, I think I did that last time as well.
Thank you very much, Your Honor.
All right, so is that it for today?
Judge, if I may, just for the record, maintain the same objection I had at the last trial. Don't need to make any further commentary on it, just in case there's any further action, which I don't anticipate right now.
Okay.
But just for the record, thank you.
Okay. All right, so we're all set until Tuesday, I believe. I'll get
Thank you.
orders out. Oh, stipulations were just given to me. I have not had a chance to read them.
It's a reasonable order. You have a side quest case that connects to witnesses in this case. There are going to be stay away orders in that case. It makes sense that that is the ruling. The defense has the right to object to it, but it is a narrowed ruling. So the court ruled that he being Aidan Kearney is not going to be sequestered except for the witnesses that will be listed out that there are indictments pending as to. That's what they did in the first trial. Also, the court said in the first trial, because the media is running on like a lottery, but if he has a lottery seat on the day that those witnesses are testifying and leaves for that witness and comes back, he will not lose his lottery seat. So the court made sure that it wasn't well, if you can't come in for this witness, you're out for the rest of the day, and went kind of in a more narrow fashion of parsing it, which I think is a reasonable parsing given that there are still open and pending indictments. Let us continue.
All right, this looks like you all made some progress in a way where the jury will be happy that you've cut down the amount of time that they may be here otherwise. Okay.
That's good.
Anything else
like
today?
that.
The only thing I would ask.
The court went over the stipulations just there and said this might cut down some time. Stipulations means the parties are agreeing. The parties can agree that the tables were high tops. The parties can agree that it was snowing. The parties can agree that if this witness was called, they would say XYZ. There are stipulations that they can put in, and it's like, hey, ladies and gentlemen of the jury, you're the fact finders. These things have been agreed to from the parties, so you don't need to worry about them. And the court said that'll cut down some time. Yeah, the facts at issue are at issue. The facts that aren't at issue shouldn't be at issue.
The court to consider is with regard to the speaker, the reader issue.
Oh, okay.
If the Commonwealth intends to go forward with that, I would ask that that be put in a formal motion so we have something to respond to. I think research on that is in order.
Oh, okay. Sure.
Doesn't have to be lengthy, and
it is something that we've done.
Right, understood. I would like to see what I'm going to have to look at what the law in Massachusetts is concerning that and what the sort of parameters are.
Okay.
I just think because of the potential prejudicial effect on Ms. Reed, I'd like to have something in writing.
Why are you so mad about this?
It is in the extrajudicial motion. If there's something separate the court wants briefed, we're happy to do it, but it's already in the motion that we provided regarding extrajudicial statements.
This is a losing battle. I don't know why we're fighting it. Like, why are you fighting that one?
Tuesday.
Thank you.
All rise for the vote, please.
I don't know why the defense is mad at that. Well, I speculated earlier, but AJ's not going to win on that motion. He's not. That's not an uncommon thing. I understand why he doesn't trust Brennan, though. Like, I get it. And I think they should have to disclose who the reader is. And I think there's parameters for who the reader is and how they do it. But this is not an unusual thing. And it's when you have lawyers do it, it's pretty easy to control because lawyers are obligated with their duties to the court. So let's summarize what happened today, shall we? Let's do our best to summarize what happened today because We're done with court for the day, y'all. It's not a, look at us. Look at us. Chat, look at us. It's noon. It's noon. And well, Central. It's noon for me, and we are done. You know what? Why Emily's heart's happy? 1, because we did it. 2, because I'm going to a concert tonight, and I would really like to put together a charcuterie board, and I haven't had time to go to the store, and so my day is 100% made because I have time to like finish doing laundry and shit. I am so excited. Look at us getting it done today. Here's where my head's at with all of that. Opening statements start Tuesday, and we are going to be in court for like 6 to 8 weeks. So as we get to streaming tomorrow, unless something just pops off the rails, I am not going to stream tomorrow. I am going to prep our episode of the Emily Show podcast that will drop on Monday on the Emily Show channel. You're going to notice some changes over there as we put together our, we're going to be changing the name because like Quick Bits just doesn't fit anymore. It did when we started that channel, but it's just like lies at this point. It's just lies. And that channel has grown really into the Emily Show podcast and case briefs where we summarize what is happening day by day in court in really truly a case brief format with clips from court and my summaries, but not really stream clips because they are much more curated than that. So the second channel is undergoing a bit of a makeover. We love that for her. And you will see some changes over there. You'll see that it's named The Emily Show. So I'm going to make sure that there's some interesting stuff I want to talk about. We're going to make sure that this week's podcast gets done early. Members, I want to make sure that I get to record with y'all. I'm going to try to do that on Friday. So we'll get to do it. And then I really want to get that done early because I don't want Team Baker to have to work over the weekend either. I don't want the mods to have to work as we are getting into a very heavy stretch of trials. And this case is going to be long. We're going to get into Donna Adelson. That's going to take some time. And then by the time we get to Koberger, everyone's already going to be tired and we are going to be in trial for months and months. They're going to start evidence in August. They won't be done till November. So as we get into take time where I can find it, I am going to take time where I can find it as we're scooting into really busy trial time. And I think that's healthy for Team Baker. I think that's healthy for the mods. And I think that's healthy for me as well, because trial days are long days and they can be exhausting days. And yeah, we're going to take the breaks where we can find them because we're all about balance, y'all. We're all about balance. So look, you got to do it when you're out of heavy season at work, you got to take those breaks. So we're going to do it. For all of you that are commenting that the attorneys look tired, the attorneys are already tired. The attorneys are already tired going into what is surely a very long time. And for the attorneys that are from out of state, Alessi, Jackson, Attorney Little, they're essentially moving to Massachusetts for like a 3-month chunk. I don't know about Attorney Little. I know that Jackson has kids. Like it takes a toll on your life doing a trial like this. I can't imagine what it's like to also not be home. I mean, there might be a benefit of like head down and focused and like nothing else matters, but it's also wow, I'm not home with my people in my own bed, which truly, I love my people, but I also love my own bed. So it's going to be a long trial. So that's the plan. And then we will resume with opening statements on Tuesday. So I'm going to summarize what we did today. I'm going to answer some questions and then we're going to bounce. We're all going to that's enough work for this day, people, as we get into busy trial streams. Busy. Let's try to do a summary. Well, Cam and the Rev, and then there's Jeff, said if you haven't downloaded it, the Lawnard app has been great for us to keep up with what's going on. The Lawnerd app will let you know when there's a new Emily Show podcast, when there's a new case brief, when people take the stand. You better believe the second that former Trooper Proctor gets on that stand, you are getting a Lawnerd alert. We're going to send that shit out so fast through the app. So if there are times when you're like, I'm not going to be able to do full trial days, the Lawnerd app will notify you as different witnesses take the stand. So if there are witnesses that you are like, I really want to see this witness testify, with the civilian witnesses, we will be sending those out. With some of the law enforcement witnesses, when we get into the expert stuff, we'll send that out. So 100% we will keep you in the loop. I am not sure what time court will start on Tuesday. It will either be 9 or 10 Eastern time, and I will let you know when we're going to start. I'm going to start pretty close in time to real time for opening statements because I don't want to miss it. Also, at this point, we've been like, this is a Lawnerd point of pride for me, but we are, by live concurrent viewers, the #1 place to watch trials on YouTube. And we're not going to catch the Lawnerd slipping. I want to see opening statements the second they start. You want to see opening statements the second they start. I'm probably not going to pause much during those opening statements because I want to see truly how they come in, and then we'll talk about it afterwards as we get into the initial witnesses. Because I need to know, you need to know, we need to know, we need to know, we need to know. So between 9 and 10 Eastern is when I think court will start on Tuesday. There will probably be some delays, but the jury will be back on Tuesday. Let's summarize today, shall we? What's with today? The court wrapped up a lot of loose ends in the hearings today that we all watched together. From whether or not Aidan Kearney, aka Turtle Boy, will be excluded from court during all of the testimony, just some or somewhere in between, to what exhibits will be used during opening statements. And we saw the Commonwealth have an absolute just hissy fit over ARCCA, because of course they did. Today was a lot. Let's talk about ARCCA real quick with the Commonwealth. Attorney Brennan was just yelling in court today, saying that they do not have discovery sufficient on the ARCCA witnesses, that the Commonwealth, that the defense is engaging in trial by ambush, and that new opinions by ARCCA at this point is unfair. And he reiterated with actually a hand slap on the podium, I am not saying that ARCCA can't testify. I am asking the court to order them to turn over discovery and to constrain their testimony to the opinions that they've turned over. And the defense said, Your Honor, we can't do our work if they don't do theirs. It was his 50th birthday. They turned over their Dr. Welcher to us late. We didn't even get that shit till February. So how do we have our experts look at what their experts said if we don't have what their experts said? So the defense said the only thing new that ARCCA's been given is the Commonwealth expert information. And they gave ARCCA the report from Dr. Welcher, which was the 140 PowerPoints of whatever on accident reconstruction, and the materials that Dr. Welcher looked at to review their experts. Having experts check other experts is a regular part of court. And the defense said, we didn't even get that shit till February. And then we had to do a request through the federal government to be allowed to hire ARCCA to look at this for us. And they didn't get that back to us till March 26th. So we're doing the best that we can. And the Commonwealth is aware of this. But in Brennan's argument, he said, Your Honor, we can't have new opinions coming in from ARCCA after we've made our opening, after we've told the jury our theory of the case, after we've presented our science. And as I was streaming, my pondering on that was, your case should be solid no matter what holes ARCCA tries to poke in it. Your science should be solid. Your case should be built on your evidence, not a rebuttal to the defense. And where the Commonwealth was constantly on the back foot in trial number 1 was that they were trying to prove their case and simultaneously disprove anything the defense might say. And it got way too convoluted, and their theory of the case got lost. What, if any, theory of the case was presented? And if the Commonwealth is going to try their case by disproving the defense, they are going to end up in the same position where their case is not clear. The Commonwealth needs to try their case based on their evidence and their theory of the case. The defense needs to try their case based on the Commonwealth didn't prove any of this to you. If they keep it simple, I think it will be much easier for a jury to understand, because at the end of the day, there will be medical testimony about whether or not John O'Keefe was hit by a car. And if that becomes the focus of this case, I think it will be a lot less confusing for everyone involved. But when there are a million different rabbit holes to run down, that simple point gets lost. Was John O'Keefe hit by a car? Was Karen Reed driving that car? That is the core of this case. And it got very lost in different aspects of the first trial. So the court didn't rule on that yet, so hopefully we'll see that ruling by Monday. There was some discovery conversation. A lot of it got worked out. There was conversation about what will be presented in opening statements, which we see are going to be done by Attorney Brennan and Attorney Jackson. The Commonwealth said they're going to be using what looks like a 15-second clip of one of the interviews Karen Reed gave. The Commonwealth is going to use Karen Reed's media interviews against her in this trial. And the defense is going to use the internal affairs investigations against the, state troopers and former state trooper Proctor against them. And so all of that was hashed out today with, yes, the Commonwealth can use Karen Reed's media statements. That's appropriate statements of a party opponent. And yes, the defense can use the findings from the internal affairs investigations as to former Trooper Proctor, Trooper Buchanan, and Trooper Tully. Those are going to come in. And then when we got to the very end of the court day, we had a hearing with regard to whether or not Aidan Kearney, I'm going to keep pronouncing it wrong, Aidan Kearney will be excluded from being in the media pool during this case because he's on the Commonwealth's witness list. And his attorney came into court and said, if you call him to testify, he has 16 pending indictments for witness intimidation, and we disagree with the Commonwealth's reading of that statute. That disagreement aside, if he's called to testify in this case, he would plead the fifth. And the Commonwealth conceded if he pleads the fifth, if he pleads the fifth, then we do not have a good faith basis that we can call him as a witness. And then they just hashed that out. There was a colloquy between the judge, between Attorney Bradel, I just can't talk at the end of the day, between the judge, Attorney Bradel, and Aidan Kearney, and they discussed, the court made a finding on the record that he has reason to plead the fifth, that he would plead the fifth if called to testify. And when the court made that record, she then ordered that he would not be subject to the sequestration or exclusionary order, that he would be allowed to be in the courtroom except for the same conditions that we saw in the first trial, which were the juvenile witnesses, which there's a full media blackout on, and for the witnesses who are part of any of the witness intimidation indictments. There are stay away orders in those, and he cannot be in the courtroom for those witnesses. So same order as the first trial with the added step of the Commonwealth adding him to the witness list, and he will be allowed to be present in court as there is media access. It's my understanding that all media access to the court is on a lottery system that's pulled weekly. So week by week, I'm sure the gallery will be changing. And that is where we're at before opening statements start on Tuesday. Will more happen? Probably. And we'll talk about it either, on Tuesday before opening statements start or in the Emily Show podcast on Monday. Let's get to your questions because you've got them, I've got them, we've got them, right? We've got all of the questions. Let us question. That was the wrong one. That was the wrong one. Well, that feels better. First and foremost, for everyone who gifted memberships, y'all are so incredibly kind and generous. Tracy Walker, thank you. You've gifted so many memberships today. B2, thank you. J. Michael RN, thank you. Everyone who gifted memberships, thank you. Also to the mods, apologies. We have just broken slow mode because we have so many members and members don't have slow mode. So for those of you that are like, the chat's going too fast. Well, a large part of our chat is members, and members aren't slow moded. So yes, our membership does tend to grow during trial because people don't want to be slow moded, and I completely get it. So good to see you, J. Michael, who said, hi friends, so excited to spend the afternoon with y'all. 3 weeks until I walk across the stage for my MSN. Y'all have been my ride or die. I can't believe you're already done, J. Michael. I remember when you were starting. So congratulations. So excited for you. We have a couple congratulations in the chat and a number of you celebrating just incredible accomplishments. Chrissy had to be deposed on a work matter yesterday and brought the emotional support Matt Black Law Nerd Tumblr. I love it. Hopefully the attorneys were shook. They're like, speaking our language, no tricks here. And I hope it wasn't depositions aren't always fun, but hopefully on a work matter, it's like, I saw what I saw, I did what I did, I know what I know, and that's it. Perfect. And then Shanghai Sherry said, did this neurodivergent 60-year-old just get her master's in forensic psych? Celebrating with the law nerds? Yup. Sherry, congratulations. I am so excited for you. I'm sure Dr. Curry would also be cheering you along on your journey to endeavor into forensic psych. Congratulations. And I know I saw tons of the law nerds also congratulating you because that is a tremendous accomplishment. I get asked quite a lot, is it too late to do X, Y, or Z? I always say cost-benefit analysis on time and money is the first part, but it is never too late to learn something new. We learn new things every day. We are humans. We continue to learn and grow and evaluate and change. And I love the endeavor. It is never too late to learn and grow and change. It's never too late. So I'm so excited that you endeavored to do it. And congratulations. Congratulations. Sarah S. said he gives child not getting their way energy. Oh, Brennan was just on one today. There were moments where he was accurate, but it got so overshadowed by, I want it now, Your Honor. It was like, sir. I'm interested to see if his trial demeanor is the same or different, but you got Emily, Petty Betty Emily. Look, there are times Brennan hasn't what if anything us into our early graves at this point. There is no word salad. I don't always agree with him. I don't always like his tone. There is no word salad here, but I know there are times that Brennan is on my last nerve quite a lot, and it is really the arguing like a defense attorney when you're a prosecutor. It's too much. It's too heavy-handed. I think it will rub the jury the wrong way. But hear me out. Brennan doing the direct examination of former Trooper Proctor. I think Brennan's going to bring the smoke. I think Trooper Proctor is going to be the Commonwealth scapegoat. It's going to be like, the investigation was fine. It was just him. And it wasn't, he's just bad. It's just a bad investigation. It's not nobody's being framed. Nobody's planting evidence. It's a bad investigation because he did a bad job and he is the problem. I think that's where the Commonwealth's going to go with former Trooper Proctor. But it's going to be real interesting to see if Trooper Proctor brings the smoke, and it might be part of their case. Really, the investigation wasn't all bad. Proctor was bad. The rest of it was just unfortunate and regrettable and circumstances and weather. So I'm real curious. To see how Brennan goes after like Higgins and Proctor. I think it's going to be real spicy. I'll be a little disappointed if it's not, I got to be honest. Yeah, I will. I'll be a little disappointed if it's not. Like, maybe it won't be, but I can see the prosecution going that direction. Truly. So we're going to see all of the blame for everything falling on Proctor's head. And then the rest of it, I think, will be the snow. It's like, well, they couldn't put up crime scene tape. The snow. They couldn't collect evidence. The snow. They couldn't interview witnesses separately. The snow, like it's just gonna, the snow and former Trooper Proctor, that's what's gonna catch the smoke. So we will see. We will see. Like Queen said, thanks for body doubling for me while I work on organizing my craft stuff. Oh, there's a lot of stuff. I get it. And also ADHD. Look, somebody on social media said that there needs to be like a swipe right, swipe left style dating app for people who are ADHD and hobbies. So it's like, I've moved on from this hobby, but maybe you match with this hobby. But you know, because ADHD, before I even tried the thing, I bought all the stuff to try the thing. And then I tried the thing and went, and to take an app and to match people with like, this was my hobby, here's the stuff for you as you embark in this hobby. I think it would be fantastic. I think it would be a lot of fun because there is definitely stuff that I need to de-stuff. But it's like so much stuff that I don't want to just like get rid of it. But it all goes together and it's like, take all of this and enjoy. I should probably just like Facebook marketplace it, right? Like the ADHD hobby swap. It's like the marketplace for hobbies. Yes, it needs to be someone like a specific Facebook marketplace for hobbies. I wouldn't be mad if it was a consignment store. I really wouldn't. I wouldn't be mad if it was a consignment shop, but I think by mail works better. It's just, it would be so fun. It might also be detrimental because then you're like, oh, we've uncorked all of the hobbies. I'm sure I have an old Cricut somewhere. Like the photography stuff I'm never getting rid of, but I'm sure I have a Cricut somewhere. Like I have paper crafting supplies somewhere. I am terrible at paper crafting. The more I learn about myself and the fact that I don't have any like mind's eye at all, the more I realize that visual hobbies, like creative hobbies in that way are a no for me, are just a no for me. So Maggie in the chat said Reddit has a Reddit/craft sharing. Oh, there you go. Look at Scrapped Lanta in Atlanta. Oh, I like going to Atlanta. Atlanta's got good shopping and a Kura. Makes my heart happy. All the traffic though, and like 15 lanes of highway going each way. That's only mildly hyperbolic, but the shopping. It is 10 out of 10. There's decent shopping in Nashville, but Atlanta has like all the things. All the things. So let's see. Melissa said Brennan gave Veruca Salt vibes today for sure. MYB said that Turtle Boy's witness intimidation and harassment has been ignored by lawtubers. I don't know what other people are covering or not covering. I have not, and I said this during the first trial, that I wasn't diving into the trials to the side of this one. So I can understand why it would seem that I'm ignoring it. I'm not. There are pending witness intimidation indictments, but do I have the bandwidth to go down that case and say I know everything about it? No, I don't. Am I making factual determinations about it? No, I'm not. Do I know the facts of that case? No, I don't. Have I read all the indictments and all the information? No, I haven't, because I just don't have bandwidth to side quest off of the main quest in this case. And I didn't in the first case, and I'm not going to in this case, purely for me, based on bandwidth. There's a lot more information there, so I'm not going to comment on something I don't have full information on, other than it exists, it hasn't gone to trial yet, and it is to the side of this case. But am I here to navigate the ins and outs of who said what happened? Nope, because it's a whole separate side quest, and I'm behind on like 4 other side quests. So I pick and choose by bandwidth, and I do not have bandwidth to cover everything that I might otherwise cover. So I just truly don't. Just one person, and I do all of my court documents and stuff myself because it's important to me, and there are aspects of control I'm not going to let go of. Dirty Karma said, I found you in Deputy Heard and can't watch trials without you. I think the law nerd community feels that way. That's why it is the most fun place to watch trials. And a lot of you are like, I've tried watching this, and without the explanations, it's not as fun. I know. We have fun here together, and I love it. I do. It's fun. So let us continue on. Carrie and the Cats said, this is the only case I followed with you from the very beginning, and I'm really losing faith in the judicial system. Carrie and the Cats, I understand how you feel. I am not going to tell you how you should feel. I would offer my perspective on this just a little bit. Transparency is good. We are getting transparency in this case. Without transparency, I don't think the folks in Canton would have pushed as hard as they did for the Canton police audit. I think the Canton police audit, though I don't know if Canton's happy with it or not happy with it. I imagine there's like, how are we okay with this? But they pushed for process to move forward. The judicial process works slow. And sometimes it can take years to get it right. Is it always perfect? No, it's not. It is a system with humans. Humans are not perfect. But we have seen IA investigations into officers. We have seen this trial bring to light an investigation that ended up with Trooper Proctor being fired. Though the wheels are slow, we have seen a lot illuminated. Also, just covering cases where everything's going well, I don't think helps. Covering cases where things aren't going well also highlights where things aren't going well. And overall, in the cases that we've covered, I've looked at the jury results and been like, I understand how you got there. This case is difficult because there is so much. It's not just like a one thing or a two thing or a three thing. It's like this. It's so much. But there's a lot of transparency being brought to it, and that's a really good thing. And process is moving, and that's a good thing. We will see what the jury does, but I would like to know at the end of this case, and this is what's going to be hard in the retrial. At the end of the retrial, I hope to get to, I see what the Commonwealth put in evidence, I see what the defense put in evidence, and I understand what the jury did. That is where I hope to be at the end of this case. I have modified where I hope to be from the first case a little bit, because remember, in the first case I said, I hope to understand what happened to John O'Keefe. I would like a clear answer of that. And I've had to walk that back a little bit and modify my expectations. But I want to see how this case comes in. And the thing that troubles me about what I've seen on the internet about this case, and when I say internet, I'm not talking about the law nerds, I'm talking about the other side of the internet. But I've seen a lot of comments that trouble me, like, well, if she had nothing to hide, she should testify. And the defense is causing XYZ. The perspective from every case that I come in with is the prosecution has to prove their case. That's how our system's set up. The prosecution has to prove their case. And if I think they're doing a good job at that, I'm going to tell you. If I think they're doing a shit job at that, I'm going to tell you. The prosecution has to prove their case. Karen Reed doesn't have to prove shit. Karen Reed's attorneys don't have to prove shit. I criticize them when they overpromise. I criticized Poot in the Murdaugh case when he overpromised. It is not on the defense to prove that they didn't do it. It is not on the defendant to prove that they didn't do it. Whether or not you feel that it could have happened, it is not on the defendant to prove they didn't do it. It is on the prosecution to prove that they did beyond a reasonable doubt with lawfully obtained evidence and credible witnesses. And it is for the jury to decide. That's it. That's the case. And so that is my focus of the case. In some cases, people wander in and are like, oh my God, you're so pro-prosecution. In some cases, people wander in and are like, oh my God, you're so pro-defense. I'm pro everyone doing their jobs. Big fan of justice. And if the prosecution's not doing their job, they're going to catch a lot of smoke from me. But when the prosecution is doing their job, they're not going to catch smoke from me. Which, sometimes the comment section, not the chat, but sometimes the comment section isn't happy with. CEG, the AT&T reports R.E. Koberger. People are like, the state's hiding this, the state's hiding that. I'm like, I haven't seen it. And their explanation's reasonable. So yeah, do I have issues with the Canton PD videos? Sure do. Do I have issues with the 7-second timing records on AT&T? No, not without more information. Right now, it's much ado about nothing. Can that change? Sure can. Sure can. I'm pro everyone doing their job. And my goal is to focus on what the prosecution has proved in every single case. Because that's what's required. What can they prove? So I see myself a lot like a sports commentator, and I'm always rooting for a good game. I want to see fair plays. I want to see a good referee who's not calling it more for one side than the other. I want to see excellent lawyering. I want to see good witnesses. I want to see a good case. And sometimes we get it. And sometimes we're like, oh God, what are we watching? And sometimes it varies day by day and witness by witness. But that's where my perspective is on all of this. And that's where I think we all should be. And I understand that it's hard because how court operates and how we operate as a society are not the same. Our society will oftentimes convict first and ask questions second. They're like, yeah, this person did that thing. Prove to me that you didn't. And that's not how court works. And as social media moves faster, people tend to, not the law nerds, y'all know, but we can tend to look at a headline or a quick snippet of a story and be like, that's fucked. Why'd that person do that? And not go much deeper with it in our everyday life. Our brains make decisions real fast. Like, am I safe? Is this thing going to eat me? Do I need to run? Should I catch that Pokemon? Like our brains move quickly and the court process does not. And the court process takes brains move quickly and we judge things all the time because we have to, and slows it down and puts process around it and says, in this bubble circumstance, we have to approach it differently. And we have to approach thought process differently. And we have to approach decision-making differently. And it's different than we do it out in the world. And so sometimes what's happening in court feels really out of alignment with how we would operate in the world. For all of you that watch the Kohberger arguments, especially some of the death penalty arguments, you're like, yeah, I am rubbed super the wrong way. My dander is up. I hate all of these arguments. Are they court appropriate? Yes. Do they bump up against how we might see the world or engage in conversation outside of court? Also, yes. Also, yes. And it's hard to keep those things separate and be patient for court. Court is so slow. I hope that when we all slow down, and I hope that when court slows down, it gets us to the right result. Because everything else moves really fast, and sometimes it's really uncomfortable to slow down. And it's real uncomfortable to wait for an answer. This case is getting more and more uncomfortable to wait for an answer. I see that you guys feel it. I get it. And there are times even when doing what I do, explaining how both sides are working frustrates people. Because it doesn't mean I'm saying this side's right, this side's wrong. But trying to explain both sides, some people are like, I don't want to hear what the other side says. And you explaining it means you're with them. Nope. We need to understand what both sides are saying in the court of law. It's an adversarial system. It doesn't mean we agree with one or the other, but we have to understand what's being said. And we've gotten to a point where sometimes it's really hard to engage in conversation and talk about both sides of a conversation without people feeling attacked. And in court, that shouldn't happen. And in court, you have to evaluate both sides and be able to have a conversation without it being so much, well, if you're talking about what this side has said, then you agree with them and then you're wrong. That's not how we operate in court. And I want to be able to see the lawyers making the plays and explain, well, Fred, what are you doing? And explain why those things are happening in court. And I hope that I can continue to do it well. And that's my goal, is to explain what both sides in court are doing, whether I agree with their argument, disagree with their argument, see their point, don't see their point, like what they're saying, don't like what they're saying. It's my job, as I see it, to help you understand it. Even when I don't like it, even when I don't agree with it, or if I'm neutral to it. So that's where my face will tell you where I'm at. Just because Brendan rubs me the wrong way sometimes doesn't mean he doesn't also make good arguments sometimes. Sometimes he's right on, sometimes he's not. So hopefully that explains where we're at. And it's hard to put aside how we operate in other spaces and navigate court differently. I'm used to it because that's a space I'm used to occupying, but it can feel weird if that's a space that's new to you, because it is a very different space. It's part of why courtrooms are so imposing. You walk into court and you feel that you are in a place where the rules are different, where things are a little more formal, where things are a little more serious, where things are a little more heavy. You feel the difference when you walk into a courtroom, and it's meant to feel that way. Hey, warning, we behave different here. This is a different thing. There's a person in a robe and there's things, people sit in their assigned places. It's different. And it's hard to feel that sometimes at home, but I get to help remind us. And then we get to take a look at what the sides are doing and hope we understand the result at the end of the day, or call it out if we don't understand the result and say, well, that's bullshit, and go from there. You know, Casey Cat said it. Casey Cat said, facts, not fuckery. Yep. And if there is fuckery, we'll talk about it. And if we go galloping in the direction of fuckery, we'll also talk about it. Because some days we're just like, fuckery. Let's go. So law nerds, I know that was a long way round. But hopefully the perspective and sharing the perspective helps, and sharing how I view things helps, because it is different. And it does take some mental gymnastics sometimes to get there. And there were days in court that it was hard for me too. There were days in court where I'm like, I'm going to pop off right now. So I get it. Trisha said, I just can't round the square of the Alberts not going out to the front door. I agree with you. It's weird. It's weird. I don't know what it proves though, but it's weird. I can't either, because it's weird to me. Like, it's really weird behavior to me. And the jury gets to consider that behavior. But I think that the behavior of everyone in 34 Fairview stands out to me less than not interviewing them separately. Like, the investigation has so many issues. I don't even get to that level, because I'm like, we haven't even crossed the threshold of this investigation being sufficient for me. Chloe said, the Murdaugh case showed this clearly to me. To this day, not sure the prosecution proved he did it beyond a reasonable doubt. They did prove it couldn't have been anyone else. Is that the equivalent? I guess it depends on the jury. I think Murdaugh's testimony did him in on that case. I think if he hadn't testified, it would be different. Patty said, question, will this trial be shorter than the first? I'll let you know after we get into a couple days of witnesses how I think it's going. In theory, it should be shorter than the first. I do think Brennan will be more efficient with his time. So I'm optimistic. That it'll be a bit shorter than the last one. But with that, law nerds, we still have much of a day to get to. I appreciate you. Look at us getting done with court today early. And we'll be back here, Law Nerds, Tuesday. Opening statements. Karen Reed Trial 2 is pretty much officially underway. So we're in trial, folks. I mean, tell everyone that you're in trial for the next 6 to 8 weeks. We're in trial, folks. Chat, have a great weekend. Members, I will ping you when I'm going to be recording the behind the scenes with the members of the Emily Show. We've got lots to talk about that's not this case. So we're going to be talking about that to everyone who gifted memberships. Thank you again. The Law Nerd community keeps growing, and it's a wonderful thing to see. For all of you that I didn't ask yet that are new here or new Law Nerds, go ahead, do the subscribing things on YouTube. Apparently it still matters to them some, but it very much matters to my 13-year-old, and that's important to me because we are still having a back and forth about whether or not I am a real YouTuber. So I appreciate you for helping me essentially prove to my child that I have as real of a job as I care to have. Law Nerds, take care of yourselves, take care of each other. Always good to see you. Thanks for letting me chat with you today. I'll see you in court. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android so I can keep you in the loop. Because you never know when something's going to pop off. Thanks for being here, and thanks for being a law nerd.